How when it is going to expire? This week. Don't worry. The next week the bench will be available. No. Maybe, but we don't have a determination. We have determination till Friday. By tomorrow, Monday, the bench will be there. You go. Hey, etal niye Monday to okhane list koriye daw for extension.
Yes, my lord. Item number 22 of the today's list, my lord. Item number 22 of the today's list, my lord. I am praying for release of the matter due to want of determination, my lord. I have mentioned it in court number 32, my court number 16, my lord.
For what?
For first miscellaneous appeal, for
Admission or not admission?
Admission, my lord.
Admission is with us. Sorry. You want to get away this bench?
I kindly be permitted to mention, my lord, one extension of interim order, my lord.
When it is expiring?
Expired, my lord, 12th of June expired, my lord. Grateful, your lordship.
Yes, call the list.
Lord, what is the extreme urgency that I'm mentioning? First appeal, my lord. I have an application in the appeal, my lord, for addition of party. My lord, the matter, my lord, what has happened, my lord, the matter has already been referred to the mediation, my lord. And the parties that
What is this matter?
this matter is that I was not.
Is a first appeal,
First
second
appeal,
appeal, first appeal of which year?
2013.
20?
13.
Yes. So hearing, please wait for a time.
It's only an application, my lord. Only my application. I've not been taken.
Give application. Yes, call the list.
This matter will continue.
Item number 2.
This matter will continue, I think.
No, it will continue. These are all release matter.
Oh, to what? No, since Mr. Sanala says the
No, don't worry. Don't. We will take it with it. Yes. City court matter on my ground. Release. City court matter? Yes, release. Next. Yes, release. Yes, call the continuing matter.
Yes. But I am appearing for the appellant, my lord, in this
I am
matter.
appearing for the respondent.
This matter, your lordship will recall
Yeah.
3 title deeds, ultimately in respect of one property, one securitization proceeding by UBI Bank, second securitization proceeding by the UCO Bank, that loan assigned to Pegasus, 13.
Both of them.
Yes. 13-4 notice issued. Your lordship had been pleased to pass an interim order. Now the police investigation has revealed that the title deeds which the bank has produced are all forged. And I ultimately, on the fear of protecting my dwelling house, when 13-4 notice was issued under protest.
So your claim was 1 crore 46 lakhs.
Yes.
We have said that that amount would remain
Attached.
attached, and above that you can't. So this is what an interim order is.
Yes.
So that's an extension they want.
Yes.
But I am opposing. On behalf of the Pegasus, this is the first time I am appearing.
Yes.
Respond number one.
Yes.
First time I am opposing.
But this is an interim
But
order was passed in your presence, sir.
No. We were not there.
Yes, respondent was here.
That's a different.
What are you
Other
talking?
respondents,
Mr.
not us, not Pegasus.
SN Mitro, Mr. Rajashri Dotto, Mr. Deepak Kumar Jain.
They are supporting Mr.
No one
Seth.
is supporting it.
Anyway, my lord, we were not. We were not there. We are
No,
not.
there was no caveat.
Anyway, I am not saying. I am saying that
Well,
I
he
am
says
not. I was
as
not
an
there.
ex-party so far as he is
Yeah,
concerned.
my party is
Yes,
concerned.
that's all.
Yes.
Yes.
My lord, may I just, my lord, this suit is really barred by limitation. That's my first point. Suit is really barred by limitation.
ফাইনাল রিপোর্টটা সেখান থেকে পাচ্ছি আমরা।
We went to page 290. Annual report. 290. It starts at 293. Annual report. 295. Report document.
How the loan was disbursed by your assignor?
Yes,
I have gone through my order which I
yes.
passed
I'm-
on such and such date.
Whether that,
How
Milord,
the loan was
Milord,
disbursed?
whether that can be entertained in a suit now.
Definitely,
Milord,
at the time of passing an injunction, the court will definitely look into the conduct of the parties as well in relation to a particular transaction. As I find from the findings
Milord,
which
your
I have
lordships have
returned,
heard them. Kindly just share.
one thing which is really troubling us, which
Yes.
troubled us
Yes,
rather, and
yes.
is troubling us as well.
Yes.
There was an agreement for sale entered into between the plaintiff, that's the appellant herein, and somebody else.
Mm.
The agreement of sale does not create any title into a property. Section 54 of the Transfer of Property Act is very clear. Recently, I think last week, a judgment is also delivered by the division bench presided over by, I think, Justice Dotto and somebody else. They have also held that on the basis of an agreement for sale, no title is created into a seller. Section 54 is also clear. It appears that this particular agreement could not materialize. The owner wanted to get back the title deed. That was not given. A suit was instituted. The suit, it was said that you will not keep it with you. Ultimately, by an order of the court, the title deed was handed over to the plaintiff appellant. He got the title deed. He is in possession of the title deed now in respect of the property. Now it appears that the gentleman who was the intending purchaser by virtue of an agreement for sale has made certain, he has connived with certain banks. He has committed a fraud and got these loans and loan amount in their favor. I am really surprised because we were also surprised at that point of time that how the bank can lend a loan or advance a loan without a title deed in their possession. Title deed is with the owner. And then if that assigner has done some wrong, you being an assignee, you are bound by the act of the assigner. You can't take or elevate your status above them. Then we said that, yes, there is an amount which is there. So we have injuncted the defendants that please keep that amount in your account. Do not deal with those amounts.
Correct.
This is what the injunction
May I
Yes.
place my case?
Yes.
First of all, Milord, on the point of limitation is not whatever, Milord, I have heard your lordship's observation. Just kindly hear the other part.
Yes.
This is one part of the story, other part of the story.
Yes.
Milord, 15th September 2010, notice under section 13 subsection 4 of the SurfaceSea Act
Which one?
was
Which one? Date?
15th September 2010,
Yes.
page 246.
Yes, yes. Section 13(2) notice.
Yes, section 13 subsection 4. 13(4).
13(4) is the latter part.
Yes.
13(2) is the first notice.
Then I
13(2)A
am talking about
expired.
13(4). 13(4).
13(4) when?
15th September 2010.
13(4).
Yes.
Yes.
When the father was alive, they are the children's now who are the plaintiffs. Father was alive. 16th September 2010, Milord, and a reply was given at page 228.
Yes.
Come to this, Milord, page 228. This is 16th September 2000. That my client was very much astonished to find you that you have passed and person's notice to us so and so.
Where,
also issued a demand notice.
210? No.
16th September 2010, page 228. In my copy.
258.
228, my lord.
228.
220.
Yes.
That a demand notice dated 18 June 2010 under such so and so, but my client did not receive any demand notice from your end or for United Bank of my client does not know Messrs. Kadambari Steel or any or its director, nor had any transaction or nexus with the said company.
Correct.
My client did not agree to stand as guarantor
Yes.
or to any loan in favor of Messrs. Kadambari. My client did not sign, execute, or agree to
Correct.
any deed. That's they are
Serious.
correct.
Very serious.
That's very
Yes.
nice. Let's come one by one, Miller. The guarantee or loan agreement is my client is not connected, so liable to pay liquidation. I am showing Miller everything to your lordship. Then your lordship will
Sure.
decide. Then Miller kindly come to 25th January 2012. This is page 232. 232.
No, the page is not 25th January 2012. I think it is
25th January 2012.
it is 233.
230.
That's my
See.
copy.
Yes, 233.
Yes.
This is very Millard, important Millard. Did the father
The
die?
section 14.
Just that's a very important. Kindly.
Yes.
233. Mrs. Jyotika Bhattacharya, Mrs. Devjyoti Bhattacharya, Mrs. Abira Bhattacharya. Release of personal guarantee of Gompesh Bhattacharya and all his legal heirs for various credit facilities advanced to his friends. United of India had assigned agreement dated 13 September 2000 assigned the financial assistance granted to Kadambari so limited as a to Pegasus to so. Pegasus on the basis of the power and rights vested upon as per provisions of the above act is pleased to release to discharge Gompesh Bhattacharya and all his legal heirs from the personal guarantee from 24 January to
No, I'm not getting what you are reading. I'm not getting it.
233 Miller,
Yes,
233.
this is what a document is, 233.
I'm not in my copy, it is 233. Huh? Miller, oh, sorry, 233 kindly similar. Oh, so 232 is the sorry. 232 is the notice
231 is a notice
Taking over
issued by
position.
Pegasus
yes.
on 22nd September
Correct, Miller.
2010.
I'm sorry. I 232. This is a notice.
Yes.
Then Miller 233 kindly come. Then 233.
233 is a step under section 14 of the Sarfasi.
I think
Handing over a position 233.
234.
But anyway, in my copy it is 233.
Anyhow, 234.
Yes,
234.
Maybe Miller.
16 to 2012.
Yes, Miller. 16th February 2012.
Yes.
Miller kindly come first paragraph subject Miller release of
Release of
personal
personal
guarantee.
guarantee. Yes.
Then United Bank of Swans will be agreement. Second, Pegasus, second paragraph, on the basis of the powers and rights vested upon them as per provisions of the above act, is pleased to release to discharge Gompesh
Correct.
Bhattacharya and all his legal heirs from the personal guarantee dated 24th 2016 given to United Bank of India for various Messrs. Kadambari Steel so. The above personal guarantee are being released subsequent to payment of rupees 1 crore 21 lakhs.
Correct.
27. Pegasus and the proceeding United Bank will have no further claim on let so. Signed by the 3 persons who are here.
Yes.
Therefore, they were all well aware about the things on this 16th February 2012. Signed it,
No, at the bottom, what is there? Received.
received.
I do not know what is this. And then title deed, bearing number
Is
one
being so and so,
and NOC.
they received title deed from us.
Ah, correct.
No, title deed received from us. Now, Millard, kindly come to this, Millard. As to transfer in favor of, you have also been satisfied that Pegasus is successor in interest so and so. Pegasus receiving the amount without prejudice right to the client due under the setup from the however, without in any manner being interpreted as discharge for the borrower. Enclosed to find the original title deed. Number 113, premises number so and so, deposited late Gompesh Bhattacharya where mortgage by deposit title deed as contemplated, which was deposited with me, we have handed over.
Correct.
Whether title deed was right, wrong, forged, good, bad,
No, title deed was never forced.
Millard, just kindly give me time, Millard.
Yes.
Therefore, it was known to them, the entire issue was known to them.
Absolutely.
Absolutely right. Entire issue was known to them.
Yes. Now,
On 16th February 2012.
yes.
Further find any accepted movable assets in actual physical conditions as per list of investors so and so. Kindly next, last part one, kindly acknowledge receipt of the title deed and also acknowledge receipt of the keys to premises number so and so. And your
You have
acceptance,
handed over. You have no claim against them.
title deed was altered over.
Correct.
If something was forced, if something was done, if everything was wrong, if a suit was required to be filed, when?
No, let us see then thereafter what they did.
I am coming, my lord. One by one, I will be coming.
Correct,
This is-
correct.
This is the above with the patriot rights. This is 2012, my lord. The fact is
Correct.
that they were aware about this.
Correct.
Now, my lord, kindly come. Then, after 5 years, now, my lord, settlement letter is placed, 230, I have read it all, 233. Kindly come to 233, I have read it already, and it was signed by them. Then, my lord, 23rd June 2017, they lost a police complaint.
Yes,
23rd June 2017, after 5 years. Anyway,
correct.
kindly see, my lord, the complaint lodged by the 237. Kindly come to page 237.
Yes,
237 is the complaint after 5 years
yes.
to the Deputy Commissioner of Police South Division, so and so. Fraud,
238. Okay.
maybe, my lord,
Yes,
one
yes.
page. my lord.
237 is an, I think FIR.
My lord, that is FIR is at my 236,
Yes, yes.
the first page, and the
There
main
is one
complaint.
page missing.
And one page is somewhere. there.
Yes.
Now, similar, fraud, perjury,
Yes, preparation of false.
preparation of false documents for the purpose of cheating, so and so, etc.
Correct.
They were even, I take it, 2017, they were, the first time came to learn.
Yes. Yes.
Your lordship's observation was it was forged, not correct. Everything, 2017, they were aware about this.
Correct.
First I said 2012, then the 2017.
Correct.
Now, my lord, this is the allegations also against us here.
Correct.
We have been made accused here.
Yes.
2-4. My lord, details of given, they have given it. I am not reading, my lord, 245, 243, kindly come to your lordship's page, it would be maybe. Kindly see 243, name of the accused person, Piyush Lodha, Parameshwar Devi, Honorable Vitto, all the district of Swanpur. Next is 6, Indranil Chatterjee and Rajiv Nair of Pegasus Assets Reconstruction Private Limited, so and so, so and so, so and so, so and so.
Yes.
Right, Millard? Now, on the basis of this, Millard, the report under section 173, subsection 8 has been filed. That report has been filed, Millard, on 2nd December 2020. This is that, kindly come to page 290,
Yes.
290, 293. It starts from 293 at my page, Millard,
Anyhow, that will be 294.
294. Millard,
Charge sheet is
yes,
293.
now come, Millard.
Yes, charge sheet.
Now come, whether this saves the limitation at all or not. Millard, your lordships have mentioned in your lordships earlier order, the moment it has been filed, the suit has been filed is not correct.
Yes.
They have said to your lordships, but it's not correct. I will show to your lordships.
Yes.
This is on 22nd December 2020.
Yes.
The brief fact of the case that the FIR named accused person and others entered into a criminal conspiracy to deprive the complainant from his legitimate rights and in pursuance thereof prepared forged deeds in respect of so-and-so, now so-and-so. The relevant documents were seized, including the third deed by so-and-so. During investigation, several attempts were made to trace out the two components styled as Messrs. Kadambari Steel and Messrs. Tirupati Textile, in favor of which so-and-so, এটা আমাদের তো না, which we are only Kadambari, of which locus were obtained, loans were obtained for UPI, Park Street Bank from UCO Bank.
You are Kadambari or Pegasus?
Borwar is Kadambari.
That is, I know. Kadambari and Tirupati, they have said two
Yes,
persons.
yes.
You are a Pegasus.
I am Pegasus.
Yes. No, you said I am for the
No, no,
I am Kadambari.
so far my case is only Kadambari.
Yes.
The DRT3 Calcutta Messrs. So and so. Now, Millard, kindly see. During investigation, the LICI authority was contacted and on being asked, they stated that the amount is seized title deed and seized from Messrs. Pijus Lodha is the original one. So it is pertinent to mention the title deed used to get loans from UCO Bank, Sambazar branch and UBI Park Street branch at forged deeds, right? Just তোমরা সবাই এরকম কনস্ট্যান্ট যদি কথা বলো আমি কি করে করবো বলো তো বলো এমনিতে আমি একটু ডাল হেডেড লোক ভাই kindly mark it here. During investigation, the LIC
False deeds, no doubt.
they said by the LICI
Correct.
statement. Yes, statement. I will come. What is the implication of this? Whether this letter document can save the limitation at all, or I will come to that. During investigation, the document in question, including the 3 title deeds of the same property, loan guarantees, papers in respect of loans from United Bank of India, Park Street branch, along with admitted handwriting, the signature of Bomkesh Bhattacharya, since they were sent to the experts for examination opinion, the expert opinion that signature of Bomkesh Bhattacharya, since this is in the loan guarantee papers of United Bank of India, are forged signature. Moreover, also several attempts have been made, so and so, etc. Importantly, kindly come. Next, therefore, the offender who made the forgery could not be fixed up through are clear evidence of the offences of forgery. In the respect of title deed of the premises, so and so, and loan guarantee papers in respect of loans from United Bank of India, Park Street branch, so and so. Then, skip one paragraph. Then, during investigation, sufficient evidence could not be collected.
Yes.
Sufficient evidence could not be collected. So
That is what it really struck us, and the gentleman assisting you knows that why. If everything was found that the documents have been forged, LIC has handed over those title deeds to the investigating officer. Investigating officer says that the offenders who have done that, there is a clear case of a forgery, and then FRT.
who will take these steps?
FRT.
Under the law, who will take this step? FRT is there. Who will take this step? I have been discharged. Who will take these steps? That's the judgment. That's exactly I am saying. If the FRT is there, who will file the RIG petition, my lord?
Then what?
Then since your lordships have said this, observe this. If everything is there,
No, we
correct.
know.
Let us understand is correct. I have been discharged.
Yes.
So who will file this protest petition, which is
Let
called
us-
an RIG petition?
Let us go in that.
By whom?
Yes.
Accused? Sorry, complainant?
We are
Now-
not making
now,
any comment on the party.
I am
We are
coming.
making
No,
comments
I am.
on an
Yes,
investigating
this is
officer.
therefore
Than that.
my lord has been taken into consideration this document for the purpose of saving the limitation.
Yes.
For saving the limitation, your lordships have taken into consideration of this document. How this document can save the limitation?
Let us
This
see.
document
Let
is-
us see. Let us see the limitation part. Let
But-
us see.
Now, lordship see it.
Correct.
Under such circumstances, the investigation into cases is closed, declaring as final report true, and the FIR named accused person named is so and so. I am only super Indranil Chatterjee and Rajendra Pegasus. Limited others are discharged.
Correct.
This report has been filed.
Correct.
This report, neither my lord any Naraji petition or the protest petition which has been said by the Supreme Court.
Yes.
If you have
That is under the law. also.
under the
There is
no,
difficulty.
not under the Code of Criminal Procedure. This law has been made by the Supreme Court. This is a law,
Under the law,
judge-making
that's
law.
why I say law declared by the Supreme Court is a law.
Of course, I am saying that this is a judge-making law, and it is the now all over India. It's going on. It's a
Absolutely, you are correct.
judge-making law.
Absolutely
Therefore,
correct.
this is the accused or discharged, case is not there against me. How can you say that I am guilty?
No, Mr. Bandyopadhyay, there are two things. One in relation to a criminal liability, one in relation to a civil liability.
Correct.
So far as a criminal liability may not be there, but one cannot deny that particular civil liability under the law,
My lord,
because under the criminal jurisprudence.
my lord,
you know
I am
that
today
how
exclusively
the
your
cases are-
lordship's field. Today I am a 100%, 1000% of your lordship's exclusive field. I know that. I understand that. I am a, yes. And your lordship may today, yes, Mr. Mondo, I got you. I will catch there. I will catch there. That's all right. I know that.
Sir.
But my point is very clear. Malad, kindly try to.
Only one thing that is,
My lord.
Mr. Bandapatiya, I must be very candid to you. As you know, that I always.
Yes,
express my
always,
mind.
always
I
open.
always express my mind.
Yes, always open. That's good.
It's very clear, very clear. There has been a fraud or a forgery that was committed. And if I correctly remember, on the last occasion when we passed an interim order, there was an argument advanced showing all these documents were placed
Correct.
before us. Because I find there is a underline and all
Yes,
everything
yes,
that
yes,
shows that these documents were placed.
Yes.
That shows that a gentleman who was really coerced or rather forced to get his property clean or cleared from the clutches of all these unscrupulous persons. Though he said that I was never a signatory, never a part, even an investigating officer's report says that the signatures are all forged. He never put their signatures on that. Yet, in order to get it, he paid them out and got it released. Now the question is, thereafter, I believe there was a suit which was filed.
Which suit? That's the
I do not
point.
know.
That's exactly. Milord, I tell you, Milord, unfortunately, our law does not give relief to a person who is sleeping over the years. That's the reason limitation. That's the reason. Let me take it. He is having a very good case. Very good case for argument's sake. Why you are sleeping?
Even on evidence.
Huh?
Even on evidence, he has one of the best case.
Best case, Milord, in 2012, he got the deed. He got the title deed.
How can I tell it? Why, how is
তোমরা এসো 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 এসো। আমি ছেড়ে দিচ্ছি এসো তোমরা তোমাদের অভ্যাস যাবে না ভাই আর আমি না জানো তো অ্যাপিলেট সাইডের উকিল ভাই আমি পড়ে আসি হ্যাঁ
How long you worked with him?
বলতেই হবে আমি প্রম্পটে মামলা করি না আমি ওইটা আমাকে যে করাবে কি করাবে না সেটা তোমাদের ব্যাপার
Yes. I was a good junior.
Huh?
I was a good
Of
junior.
course, of
Yes.
but still then your lordship knows my bad habit was there.
Yes.
My lord, kindly see. I can understand your lordship's mind, or rather I can understand your lordship's sympathy for them. But whether it is a misplaced sympathy or not, 2012 you are aware about these documents were forged. Did they file any suit seeking for declaration that the deed is invalid or deed is forced, not can be acted upon? Since your lordship says that criminal liability is somewhere, civil liability is somewhere, it's all right. If you take it as civil liability, only civil act will come, then why 2012, why the limitation act would not apply? I have not also committed anything wrong. I will go by the law. Everyone will go by the law. 2012, you are aware. You have not done anything. Sleeping. 2017, lost complaint. Thereafter also slept. You are aware on that day. Now this report has come. Even after Lordship has recorded somewhere, the moment this 173 subsection 8 has been filed, immediately they filed the suit. No. When this 2nd December 2020 report was filed, when the suit was filed, 9 March 2023,
Within 3 years from then.
then therefore the question arises. Where
Limitation, in case of a fraud, the limitation arises when the fraud is made known to them. And from that day, it does not mean if the fraud is committed 10 years before, but the fraud is not made known to them, then the limitation would not arise. The limitation would accrue only when the fraud is made known to them.
Very nice.
And if they say that in December 2022, when this FRT or the final investigation report was filed, holding that it is a fraudulent one, and thereafter they derive their knowledge, and then the question.
Beautiful,
Mr. Bandyopadhyay,
I am
you know very well. So far as the limitation part is concerned, it has a unique feature. What is the first unique feature? It may be a pure question of law. It may be a mixed question of fact and law. The court, Supreme Court, invariably in a plethora of judgment has said that once it assumes a character of a mixed question of fact and law, then at the nebulous stage, the court should not invoke that provision of the Limitation Act and should decide it at the time of final hearing of the suit after giving a parties to adduce. Here also it appears to be so to us on that day. So it's a mixed question because they have to plead, they have to prove that the knowledge. If it is a pure question, there is no difficulty.
Yes, all right.
No
Lord-
difficulty. You are
Your
correct.
Lordship's query
You are correct.
is date of knowledge is important factor.
Yes, made known.
Am I right?
Yes.
If I have correctly understood your Lordship, 2012 deed was handed over. You are not serious on that.
Yes.
I mean, they were not serious. Now kindly see, on 23rd June 2017, they were aware the fraud. It was because of fraud. Kindly come to page 237. Kindly come to page 237. See. Now read below 237, maybe your Lordship's page, it will be 230. In my page, Millard, in my copy, it is 237. It may be 238. I don't know. To the from the Devajyoti Bhattacharya, son of late Bomkesh Bhattacharya. See, Millard, 230. I am just taking that one. Yes, 2012 also you was not aware that it was fraud. Come to 23rd June 2017, page 237. Read, Millard. Read. Read. Kindly read.
This is my
Yes.
Fraud, perjury, preparation of false documents for the purpose of cheating, false declaration before the court of law, mishap or so and so. That way it was within their knowledge. It may be put in the action in criminal law. But why you have not filed the petition on that date? It is the first time I have come to learn I am filing the suit.
Yes.
Therefore, this is the knowledge. Now, Millard, consider one question. Whether this would be treated as a knowledge or an opinion would be treated as a knowledge.
Mere formation of an opinion will not, unless it is communicated and made known to them. That
Therefore,
is not-
what is the effect of the final report?
Yes.
This is an opinion.
Yes.
A report filed is under section 173, subsection 8 is a opinion.
Yes.
The which date will be? If I given the Millard a full, even 2012 to 2017,
Yes.
although they are sleeping, they have got the Millard the deed. They do not know. It was forged on 2012.
Yes.
And all of a sudden 2000. And what is the explanation has been made here that from 2012 to 2017, why they did not know?
Yes.
Therefore, this is knowledge, Millard, I am saying. My first submission would be knowledge is from dated is 16 December 2012. 16th February 2012 is his knowledge, was his knowledge. Even I give him any benefit, then in that case it would be treated, Milord, this is the date, 23rd June.
Yes. Yes.
Milord, I think, Milord, when our Lordship passed the first order,
Yes. Yes, yes.
Milord, kindly see, Milord, that when your Lordship have, Milord, I have 3 points here. Number, Milord, as per my understanding of these things, Milord, of your Lordship's order, your Lordships have taken very much note and given weightage to the report under section 173 subsection way. And your Lordship was shocked to see this. Correct. This is the 3 points here. Number 1, I will give the judgments also. 173 subsection 8, any report is filed, is a mere opinion, nothing a conclusive proof.
No doubt.
Second, an evidence in the criminal proceeding cannot be brought.
No doubt.
Then third, you have not filed any Naraji petition, accepted that I should be discharged. So what the wrong I have done?
Yes.
You have not initiated any suit.
Correct.
You are sleeping tight together altogether. I could have given it. Therefore, whether the question is whether the learned court below has committed wrong, learned court below has said that I want a defense from the reply from the written objections from where I will raise this question. Certainly not before your Lordship. It has to be decided whether the limitation is there or not by the learned trial court. I am prima facie, I am showing to your Lordship, since they are granted an interim order. Therefore, interim order has been refused on your Lordships have converted the section 12 application into 30. I am not on that. It's all right. But where the learned court below.
No. Section 12 application into 13 means what?
No, sorry, order 40. Conversion code. They could have converted, your Lordships have made the observation. I am
What?
kindly come.
No. I have said that there is no impediment.
There is no fetter on the part of the court to convert
from-
the application under order 38
It
or
means
into an application order
that is an
39.
attachment before judgment and the application.
I am not on that. I am not arguing.
Yes.
But my argument is when you are sitting tight over the matter for decades together, all of a sudden you will get the interim order. Is it the law? Is it the law? Milord, if this money has been protected, if the court is having the power at any point of time to protect the plaintiff, why this ex parte order would be taken? What is the learned trial court has committed wrong? That's my point. Milord, today is not the point that whether limitation would be there or not, that because it has to be decided.
So have you been able to file your pleadings here?
No,
Is not.
nothing. I am opposing, therefore, the Milord, on principle, I am opposing this. It is not that, Milord, point is 1 crore 76 lakhs or 1 crore 20 or whatever the amount. On principle, I am opposing this.
Yes. Yes.
And my lord, your lordships were been, sorry, my lord, maybe certain facts have been said and your lordships have said. The moment the FRT has been filed, and immediately thereafter suit has been filed, it's an incorrect. 3 years have been taken by them.
Yes.
Page 50, my lord, order, kindly see the order of the, what is the illegality in that case? Your lordships will find, your lordships will examine today in this appeal that whether the order is illegal or not.
Yes.
Kindly come to page 50. Today the record is taken up so and so. Put up petition is allowed. It appears then the Milord, it has been said
It's
Then
not
we'll-
relevant. It is, the relevant is 51,
Yes,
IA 2.
yes. Then will I two. Then will entire case has been set out at paragraph 4 of their case. Court has taken note.
Yes.
Then will kindly come to 6 on plain reading. What are the? Kindly see that he has a prima facie case and he is likely to get a favorable degree against the defendant. The defendant is either disposing or about to so and so. This is the thing that they have said. Then kindly come, Lord. Paragraph 9, whether suit circumstances exist is a question of fact. It must be proved to the satisfaction. The proof may be made either by filing affidavits or by adducing proof in this regular hearing of the suit that the court would not be justified in issuing an order of attachment before judgments or for scrutiny merely because it thinks no harm would be done.
You are,
Thereby,
Mr. Bandapatya, you are correct, because the court was proceeding on the basis that this is an application simpliciter for attachment before judgment under Order 38, Rule 5. The ingredients of Order 38, Rule 5, the court found that it is not there. That is why we said that while passing that there is no fetter on the part of the court
convert.
to convert, because there are catena of judgments of our High Court also. The receiver application can be converted
correct,
into an injunction,
correct,
injunction
correct,
to a
correct,
receiver,
Correct.
provided the ingredients are there already. Otherwise, court. We said that maybe it's not a case of a judgment on admission at this stage.
Correct.
But definitely when the case of such nature requires any interim protection to be passed, then
Correct.
the court ought to have passed an order of injunction against them. That was the total consideration
Yes.
upon assimilating the total facts which
Now, my lord,
discern from the record.
Correct.
That
Now,
is what
kindly
we said.
see now, when no protection was required from 2010 to 2023, 13 years, all of a sudden urgency would arise.
Yes.
And that was moved it was filed without serving us a notice. Today I am coming and placing the case to your lordship. Consider, no, I don't, my case has no merit. I don't mind.
Yes.
And the court has said, I need an affidavit. I need a counter from them.
That is for the purpose of judgment on, the attachment before.
Whatever it may be, whatever is the form, substance is the court wanted to know the contentions of the parties,
Yes.
whatever the form is.
Yes.
Therefore, what was the urgency? Why your lordship, today your lordship will extend it?
Yes.
Because I have a point of limitation.
Is what we said, Mr. Bandapatya. I am of the very strong view, because I am always against the mechanical extension of an interim order. If somebody has come and raises a point, then the court must record the submissions and then decide whether to extend or not to extend. That's why we are permitting you to
No
argue
doubt.
so
I'm
much.
so grateful.
Otherwise,
I
you would have
understand.
said mechanically we are extending it. And
No, I have not said that the court will not mechanically. I have said that your lordship. See, another thing.
Yes.
Your lordship directed the matter to, I am telling your lordship, directed to appear last month, 15th.
Yes.
No step was taken by them for
Yes.
bringing it in the list. You could have mentioned,
Yes.
matter has not come in terms of your lordship direction,
Yes.
at least to notice to the respondents.
Yes.
Today, before expiration of the date, one day before one will come and so that said, my lord, tomorrow limitation, interim order will expire, therefore extend the interim order.
Yes. Yes.
Therefore, my whole submission is that this is what they have said in the suit. Kindly see what is the limitation? How the limitation come paragraph পড়ো তো যে দাও 2012 and এটা দাও আমাকে paragraph suit থেকে kindly see this
Page.
paragraph suit এরকম 67 1 to page 90 মানে kindly see ওখানে সুটের ওই ছিল চলে গেছে ওইখানটা সুটের যে they have set 2 dates for saving the delay. 2 dates are 12th that February 2012. Page 91. Kindly come to page 91. তাই তো ঠিক আছে তো Are you sure?
Yes.
Now, my lord, yes, page 91. Now, my lord, kindly come to page 91. Paragraph 35. The cause of action of the instant suit firstly arose on February 16, 2012. The firstly arose.
Yes,
Admitted by them.
yes,
2012 admitted by them.
yes, yes,
And when the plaintiff had a amendment for so-and-so,
correct.
as a so-and-so to get back poison of the so-and-so, period so-and-so, and evidence of so-and-so, and hence had no legal right to sue for recourse. However, upon the said New Alipur Police Station 170 has been closed upon filing December 2020. Therefore, important question is whether the FRT gives rise to a cause of action. When it's an opinion, 173 subsection, I have brought the judgment, I can show to your lordships. It cannot be the cause of action for initiating a civil suit. And let us even take it, a FRT report under section 173 subsection 8 is hardly an opinion. No evidence is there, no evidence is proved. Secondly, it is a well-known principle of law that the evidence of the code of criminal code cannot be brought into the civil court, cannot be considered. How it can be done? A mechanism fixed under the code.
No, but the difficulty is, suppose a person who is a party to the civil proceeding has deposed something in a criminal proceeding. Can it not be used against
No,
him
sir,
in
my lord, with great respect, no.
affidavits?
With great
Hey.
respect, no. With great respect, no. I have dealt with all this matter. If your lordships see, I will bring the judgment.
I will, এই আমার লাল খাতাটা আছে,
Yes. Now your judgment.
আমার লাল খাতাটা দাও, নিয়ে এসো।
Now,
Affidavit, যদি এভিডেন্সটা দিয়ে থাকে on oath. and
another
yes,
important thing I will show to you, lord.
কেন ওখানে if he is an accused, then he is not supposed to give. Any finding which is made in the criminal will not be binding in the civil. কিন্তু ধরুন আমি ওখানে গিয়ে আমার এভিডেন্সটা দিয়েছি, on oath আমি একটা কথা বলেছি, can I not be held liable for my those statements which are made? Always, always. It's a piece of an evidence. I can bring it.
আমার কপিটা দেবো
In order to, মানে the trustworthy,
আমার বই তো
truthfulness,
আমাকে একটা মার্ক করা ছিল
the credential of the witness, এটা আমি করতে পারবো?
জজ সাহেবকে দে
So it's a dangerous proposition.
আপনি দে হ্যাঁ স্যার
Findings in the.
Well, try and take this one.
May not,
2009,
may not. They,
2009, volume 5, Supreme Court cases, page 528. 5 Supreme Court cases, page 528. Paragraph কত রে? 23. Kindly come to paragraph 24. If primacy is to be given to a criminal proceeding, indisputably, the
Eh?
civil suit must be
Yes.
determined on its own merit, keeping in view that the evidence brought before it and not in terms of the evidence brought in the criminal proceeding. The question came up for consideration in KG Pursuance is the constitution bench, where the court what emerges from the opposite, the previous judgment which is final can be relied upon as provided under section 40 so and so. In a civil suit between the same principles as this so and so, in a criminal case, once a person is convicted acquitted, he may not be tried against for the same offense so and so. If the criminal case and the civil proceeding are for the same cause, judgment of the civil court would be relevant if conditions of section 42, 43 are satisfied, but it cannot be said the same would be conclusive except as provided in so and so. Further, the judgment and order of decree passed in a previous civil proceeding, if relevant, provided under section 40, every there. Number kindly come to section paragraph 25. It is however significant to notice the decision of this court in Karan Chand Ganga Prasad wherein it is categorical decision of the civil courts will be binding on the criminal courts, but the converse is not true. My lord, with great respect to your lord.
Mr. Bandyopadhyay, probably I think I could not connect the wavelength with you.
No, I am very
No, I could not.
I have said this is your exclusive field.
No.
Here I can't play.
What I said is different things. A criminal proceeding is always tried on a basis of a proof beyond any reasonable doubt. civil proceedings are decided on a preponderance or the evidentiary value of, or there is a presumption, probability. All these things may come in a civil proceedings. What I was saying is that suppose if there is any finding returned in a criminal proceedings, take an example of section 138 of the Negotiable Instrument Act. It is not a recovery proceedings, as we all know. A civil proceeding is also filed for recovery of the amount, which can run simultaneously. There are cutting off judgments of the Supreme Court. Now, in a 138 proceeding, suppose if there is something, an adverse finding or something is made against one of the party to the civil proceedings, that finding cannot be made applicable in a civil proceedings. Because that, even if the 138 proceeding culminated into a, say, the dismissal, acquittal, discharge of the accused there, it does not exonerate them from a civil liability, nor any findings. I
Correct.
was just saying different things. One thing is, so far as the decision of the criminal proceeding is concerned, may not be binding on the civil. That is what I was trying to
Right.
bring up. So far as the civil findings are concerned, it is, because civil proceedings are being decided on a very other pedestals. It may have some impact on the criminal proceedings as well. What I'm saying is, suppose a party adduced an evidence in a criminal proceedings as a witness, and he said something there. He is a party in a civil proceedings. He wanted to say something else. Cannot that affidavit or the deposition which he made in a criminal proceeding be relied upon, be a form part of the evidence of this civil proceedings, and to ascertain that you have prevaricated? That
May I-
is
may I-
permissible.
May I give
That
this
is
answer?
permissible. That is what I was saying. I'm conscious of this.
Ma-
I can give
May
you
I can
two
give
more
give
judgments.
answer to this?
Yes.
Can I?
Yes.
For the purpose of that, the particular person can be confronted in the cross-examination with that document.
He can.
That's
That is what I'm saying, to bring on record. It just
confronted. But how far it
He-
will be relied
no,
upon?
not confronted, because he has to rely upon that this is the affidavit, this is the evidence, this is a certified copy I obtained from that particular proceedings, be marked as an exhibit. Then in the cross-examination, he can be confronted with those documents and the questions can be put. There is no difficulty in
Right.
this regard.
Paragraph 24 is very clear on that, Milord.
Yes.
Paragraph 24 premises to be given to a criminal proceeding, the civil suit must be determined on.
No, there is another judgment of Justice Umesh Banerjee in
Yes.
this. I think
Milord, then,
on the same
Milord, I
score.
can bring other judgments also if your lordship permit.
The
I can bring
principle
it
is,
tomorrow
the
also.
principle is the constitutional
Milord, keep it
principle.
tomorrow, I will bring it.
No, I'm
all
telling you, the
judgments.
principle is a constitutional principle which says that a person should not be compelled to disclose his defense so far as the criminal proceedings are concerned at the first.
No,
It
that is
cannot
the,
be.
Milord,
That's why,
Milord, kindly
that's
excuse,
why,
Milord, kindly excuse me, that law is applicable at the stage of investigation, not beyond that. When he has been before investigation, at the time of investigation by the police officer, he is having a right under the constitutional law not to disclose. But when the trial would go on, he has to disclose everything. He can't suppress the fact.
other day, there was a very unique expression which was used by one of the senior member of the bar, mostly doing the criminal cases, that all these accused, the principle of privileged liar. Privileged liar. Principle of privileged liar. He is a privileged liar. He can lie. In a criminal proceeding, you can't compel him. I believe your junior
No,
was there in
Milord,
that.
my reading of the constitutional parameters, constitutional provisions, Article 20 and read with Article 21, my understanding of the legal position, constitutional position of law is this: you can't compel a witness to say against his defense. That's a constitutional protection. That when up to the stage of investigation. That is up to the stage of investigation, not beyond that. After charge. Anyway, Milord, we are not there.
Yes.
Milord, now the question comes, Milord. ওই judgment টা দে তো 173 ওই judgment টা দে তো। ওই কাগজটা আমার
অন্য খাতায় আছে মনে হয়। মানে affidavit formed by a third party.
আমার কাছে ডাকতে আছে না জজের দুটো আরেকটা জজ থেকে
Yes.
now my lord kindly take this one also আমি বলছি জজ সব দিক আমি তোকে বলে দিচ্ছি।
ঠিক আছে।
জজ সব কি খুঁজছে তো ওই জন্য আমি কি বলে দিই। দাদা আমাকে জাজমেন্ট দেবে দেখ না। আর সব বার করবো আমার এগেনস্টে দেখ
If you want, I can give you you have cited a judgment of 2009 volume 5 SCC.
Hmm.
I am giving you two judgments, and the first judgment you must read, and the language you must also appreciate.
Yes.
That is, the first judgment is 1996 volume 3 SCC page 87. On the same principle
Hmm.
of 2009 volume 5 SCC.
Hmm.
And a subsequent judgment of this is also there, 2009 volume 13 SCC page 25,
20
which is a contra
20,
judgment.
20
Page 25. You tell your junior to bring it. It is a contra judgment.
now very nice but this is a case
Bring that judgment, 2009 volume 13 SCC page 25.
now my lord what in which stage at the evidence have not been we are in the at the stage of the FRT in this case FRT now read my lord this consider this judgment 2007 1 SCC page 110
Yes.
kindly read this my lord paragraph
MC with the Taj corridors. Which one?
MC method paragraph 26 paragraph 20. Analysis of the above judgment shows that there is a clear-cut and well-demarcated sphere of activities in the field of crime detection and crime punishment. Investigation of an offense is the field reserved for the executive through the police department. The superintendents over which vest in the state government, the executive is charged with the duty to keep vigilance over the law and order situation. It is obliged to prevent crime. If an offense is committed, allegedly, it is the state's duty to investigate into the offense and bring the offenders to answer. Once it is investigated through the police to answer, my lord, kindly come just once there, just skip 2 or 3 lines, my lord, thereafter. Therefore, there are well-defined and well-demarcated functions in the field of the crime investigation and their subsequent adjudication by the court. Largest investigation under section 173(2) of this one includes opinion of the officer in charge of the police station as to whether there is sufficient evidence or reasonable ground of suspicion to justify the forwarding of the case to the so and so. The opinion on this is not a legal evidence. At this stage of section 170, the question of interpretation of legal evidence does not arise. Therefore, my lord, the question arises. Therefore, the question arises whether the report under section 173A
Sentence.
Eh?
Last sentence of that.
in any event that function is that of the court. That of the court means criminal court.
That's why I say that
No,
it may
can't
not,
be the
it may
full.
not. Yes, I know. That is because under
At this stage,
the provision of 173, if I am not wrong, of the Criminal Procedure Code, where it contains a different provisions relating to investigation. Even a court, I mean, the judge, if he finds that the investigation has not been done in a proper manner, he can direct,
correct, further
he can
investigation.
direct a further investigation, not a reinvestigation or a de novo investigation.
No, no, sir.
He
that's
cannot.
well
That is the
settled.
domain of the High Court
High Court.
under Article 236.
Article
He
226
can
or
simply say further investigation.
whatever it may be.
So that is why sometimes it so happened that this court means definitely a criminal court. That's why I said that there is no question. At this stage, it can't, because it has to be proved.
Proved.
Suppose what is to be proved? I was not really trying to say anything to make them more wise so far as the evidence or a trial part is concerned. I was really refraining myself from saying anything. If you permit me, then I can say that what I would say the importance it will gather so far as the trial is concerned. It will have.
It will be?
It will have.
Which one?
They can go for, because it is a case of a forgery. There was an appointment of a handwriting expert. The report of the handwriting expert forms part of that particular.
Well, that's the real question. Well,
the question. Now, again, it says that this report of the expert is not a conclusive evidence.
Correct,
It is merely an opinion evidence.
correct, my lord.
But this opinion evidence can be corroborated by calling that expert into a witness box and then confronting him with, because the other side may have an opportunity to cross-examine him.
Correct,
And
absolutely.
thereafter the court, after considering the other evidence along with this particular report,
Correct, my lord.
may arrive at the conclusion that this opinion of the handwriting expert is absolutely correct, and then can form that opinion in conjunction with the other evidence.
Correct.
So that stage has not come.
Just
At
stage
this
has not
stage,
come.
I'm telling you, at the stage of injunction, there are three principles are there. The fourth principle, I have also incorporated it, the principle of jurisdiction. That court must also go into that instead of prima facie. What the court is saying that if there is a tribal issue,
There is
if there is a tribal issue
travel issue.
and the trial is required in this case, then the series of judgments are, so far as the injunction, then in that event, the court will protect the interest of the parties to the proceedings, whatever it thinks in many facets it may come. So it is, though regarded, I have held in one of the judgment, though regarded as a mini trial, yet the rigor of the Evidence Act does not apply. It is a prima facie look and the opinion which is a prima facie expressed by the judge. That is what I was just thinking about it at this stage. You file your
My
affidavit,
lord, kind similar.
take all this plea there,
No, no,
no difficulty, and the court will decide it.
no, that's all right. My lord.
Under Order 39, Rule 4, the court will decide it. No
Correct,
difficulty.
absolutely.
No
My lord,
difficulty.
therefore, today the 170 similar. This report was filed in 2020.
True.
In view of the Supreme Court's judgment, they had the right to file the Naraji petition. Naraji petition is not filed by a accused, filed by the complainant. No step has been taken. Accepted it that I should be discharged as an accused. If I am discharged as an accused, what remains with, if at all any alleged crimes over my part is concerned?
No, that is a criminal liability.
Criminal liability. But now, therefore, what I am saying, submitting, that is the point I am submitting. This report cannot save him from the limitation. What he is saying, my cause of action arose in 2012 in the plaint. Second cause of action arose on the date of the FRT. That cannot be the cause of action. Exactly, I am saying that. Therefore, civil suit, I understand that if the civil suit can be filed within 3 years from 2012 itself. Second part is, if from 2012 to 2023, no interim protection was required, why today an interim protection is required? Balance of convenience or inconvenience is in favor of. Therefore, I am submitting that the limitation, if he takes it Order 39 Rule 4 to suit, limitation clause is applicable. Without deciding that question, with great respect to your lordship, kindly pardon me, I am saying so, with great respect to your lordship, I am saying, this interim order cannot be extended, unless deciding these questions.
Yes.
These are my humble submissions to your
Thank
lordship.
you.
My lord,
I just want. Yes, there's another thing has come. Yes, I have forgotten. My junior, what do? Taking the advantage of your lordship's order, writ petition has been filed. Criminal.
What,
One writ petition has been filed
what writ
against
petition?
us. Writ petition is allowed.
What writ petition?
Writ petition has been filed against us.
No, what?
Not
writ-
only against them, against all the banks.
I against me
What for?
also.
What for?
Now, it is being taken advantage of your lordship that are
Why
going
that
from one
order?
court to another. No, I must say, Mr. Sen,
What,
please.
what for?
I am,
writ petition?
maybe I am saying all about bogus. All you are correct. But
Ah.
tell me, allow me to speak.
Ah.
But kindly see, this is the writ petition data. Yes. Kindly see the writ petition. They have filed it. What they are asking for in the writ petition now? Writ of mandamus. May I read it, below? Writ of mandamus directing the respondent 1 and 2 declare that the entire surfacing mechanism adopted by the respondent being an assigning of the respondent to extend money from the petition based on forced property, deed on forced loan, documents so and so. B. Writ of mandamus directing the respondent number 1 and 2 to issue a rule calling of the respondent why their license should not be revoked.
Yes.
What is this?
That's a separate cause of action.
No.
But
Today,
it is
therefore,
not that, Mr. Bandyopadhyay, so far as the injunction part is concerned, it is merely a prima facie opinion.
maybe,
Or
Milord,
a finding.
Milord,
It has got no
Milord, kindly see,
conclusiveness
when a
into it.
division bench passes an order, it has some impact in the minds of the single judge also.
Never.
This is,
Have you got it? Give 2009-13 SCC.
and another FIR has been lost. That will take the recourse of that.
Just give us to us.
96 টা না জজ সাহেব যেটা বললো রে 2009
No,
913
please,
যেটা
give
আমার
it
against
1996, give it to him. Small judgment, 2-page, give it to him. And the language, please read.
page 87. Yes, it is settled
no,
that the
don't-
pendency of the criminal matters would not
The language which is the first paragraph.
the appeal by special leave.
Don't read it. Read by yourself.
Threeটাই বলছে ওরা।
High Court state the proceedings of the civil suits pending disposal of the criminal case.
Language.
This appeal by special arises from the order of the High Court Rajasthan admitted the respondent company after the agreements and execution therefore post-dated checks got bounced. Yes, after the disputes were filed for recovery. Simultaneous proceedings were initiated in section 138 of the negotiation instruments. Also under section 420 of the Trichinometry, this is when the High Court state the proceedings of the civil suit pending disposal. This appeal cannot be filed against the state order. It's settled that the pendency of the criminal matter would not be an impediment to proceed with this. The criminal court would deal with the offense punishable on the other hand, the court rarely say that stay the criminal case on the compelling circumstances. We have never come across stay of any civil suits by the court so far. The High Court of Rajasthan is only an exception to the High Court proceeded on the wrong premise that refused to be said to disclose the defense in the criminal case by asking to proceed with the trial courts of the suit. It is not a correct principle. Even otherwise, it no longer subsists since many of them have filed even the civil suit on principles of law. We hold that the approach we are is not correct. So yes, but this is but this is the principle. But since I have to deal with this,
Up to this.
Okay.
Up to this.
কোনটা বলছি?
Paragraph 13 and 14.
Paragraph my lord?
Give me that paragraph 13 and 14.
এই জজশিপ ওটা তো
I have just opened it.
Paragraph?
Page 13 and 14, right hand side.
bringing on recorded document is essential for proving the case by party or
1996.
not be the court's duty being to find out the truth. The procedural mechanism necessary to arrive at a just result. We are not unmindful of the fact the court said we would be encourage any fishing inquiry. It would also not assist a party in proceeding a document which he should have himself. There cannot furthermore be any doubt that the court shall not bring about a situation whereby criminal proceeding would remain state. But this is complete, a completely different principle.
Have you read
14.
Paragraph 13 and 14?
Yes, I've read
The
it.
last sentence, you have
Yes, I've
read
read
that.
Kindly see. shall not bring a situation whereby a criminal proceeding would remain stayed as it is a well-settled principle of law that well proceeding as also criminal is pending, the letter shall be.
Let us shall have a primacy. What are you saying?
Letter shall get a, this is not the case here. I don't know, no one is seeking for a stay of the proceeding. I am not on that.
I am saying when a criminal proceeding and a civil proceeding are pitted against each other, then what is the law?
No,
Law
that
is that the civil proceeding
But
will have.
but I am on a different footing.
But here says the criminal proceeding.
Yes,
will
but
have.
I am a different, why, my lord? I tell you, this is the judgments.
I can boost it.
বসে গেছে কত হচ্ছে যাচ্ছি মার জাস্ট আমার কত যাচ্ছি 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 একটু শর্ট পাস করে নিতে পারি জাস্ট শর্ট পাস করে কত শর্ট পাস 5 মিনিটস আমি আসছি মার there is no quarrel with this proposition. In a case of what, see, there are catena of judgments. Criminal proceeding, disciplinary proceeding, which is in the nature of civil. Kindly, just 1 minute, just 1 minute, just 1 minute. If the facts are same, everything is same.
Paul Anthony.
No, everything is same. Court has said that the disciplinary proceeding would state, criminal proceeding would continue, if necessary.
Even
Normally not, but in
Paul Anthony's case of the Supreme Court has said, applied that particular judgment of the civil
and
the criminal proceeding into a disciplinary proceeding.
what?
In Paul
Anthony,
Paul Anthony's
Anthony.
case, the Supreme Court has said when the disciplinary proceeding and the criminal proceedings are launched on the same set of facts, same charges, same witnesses, same documentary evidence, and if a person has succeeded in the criminal proceeding, then that judgment of the criminal proceeding will impact the disciplinary proceeding as well. That was the judgment.
Well, that
There
is
are-
diluted now.
But
Then I
wait.
have to argue on.
Wait. That domain was not mine when I was
No,
there, but it becomes now mine
Not
when I'm
power.
here. Now I'm here.
Now your power.
No, not power. Now I'm here because I get to know of those branch of law from all of you.
Really?
You have assisted us. There was a divergence opinion in between
Correct.
that whether it should or should not. But nobody said that the Paul Anthony's case is bad. Recently, in 2021, the Supreme Court has made a very fine distinction. Upholding the Paul Anthony's view as well as the other view. What the Supreme Court says that mere acquittal will not come in the way of the disciplinary proceeding. But if it is an honorable acquittal, then that will impact the disciplinary proceeding.
Correct.
So this is what a distinction.
That is the law.
That's a balancing one. It's a balancing one which has come.
No.
So you can't say so.
No.
You have not marked 2 sentences of this judgment I really wanted you to read.
Which one? Which
You have
sentence?
not read 2 sentences which I want you to read.
I couldn't follow your losses. Which sentence?
Could not found. Whose book is this?
Library.
Should I make the underlining?
Yes.
I am very against it.
But I mark it in my book. Always. That's a very beneficial. They are calling you. Your lordship's time is.
এটা করে যেতে বলুন।
না আমাকে আটা মাটা ধরছে আমার।
হ্যাঁ, আপনি যা-
দিতে
আমি তো
হবে।
করিনি, আমার
Hey, দিয়ে দাও। And don't comment. I don't expect any
Oh,
comment.
that part that part. I have marked it. I did not want to point out. I had understood, but I did not want. I did not want to. That's since your lordship, I have marked it. I thought that only the principles your lord. I have marked it. I do not know. Without reading this, I marked it. Anyway, leave aside. Now, my lord, these are my points, my lord. Our lordship decide. This is a case where the, my lord, at all limitation.
I'll consider.
Number two, is it a case that where an injunction is required to be given? But I have another matter has been called on with your lordship.
Thank you.
And may I take only 5 minutes, my lord? Kind.
Let us come back. Yes, what do you have to say? What more? What more?
Only one thing Milord, I must, one thing I must say, Milord, that has not been said to your lordship. What, Dana. Milord, kindly come to page 281. I must inform you. This is 281. 281. It is a division bench judgment. Kindly see 2nd March 2020. Division bench delivered a judgment.
Where?
281. 281.
Yes.
মানে আমার পেজে 281, maybe my lord's page 282, my lord. The representation and appeal upon no effective order being passed to answer. That's not very important. Kindly come to next page, internal page 2, second paragraph. The appellants claim that his father had not guaranteed repayment of any loan obtained from any bank by any third party, nor did his father furnish the New Alipur property by a security to any bank. The appellants claim that his father had made moreover title deeds to an acquaintance in connection with the proposed transaction. Such acquisition may have misused the title deeds without the knowledge of the appellant's father. Then, Milord, this is the same. It is submitted on behalf of the appellant that the appellant's father came to know the fraudulent of claims of the two banks sometime around 2002. However, it does not appear the appellant's father took any immediate steps to institute a suit to recover the title deeds or to dissociate himself from the transactions as claimed by the banks. Then indeed it appears the submitted payments, next Milord, next page, were made by the appellants or the appellant's father to the, though the appellants claim that such payments were made to buy pieces so and so. The immediate grievance of the appellant is that despite a police complaint being lodged in 2000, the investigation has not yet been completed, nor any steps taken through a preliminary report that a case fraud has been discovered in course of the investigation. Just last part, one paragraph. Considering that the complaint was lodged in the year 2017 and the fact that the investigation ought to have been completed by now, the time to file the charge sheet or appointed final leader is extended till March 31, 2020. Such direction is peremptory. The state will take the matter to its logical conclusion in the event any wrongdoing has been discovered in course of the investigation. It will open to the appellant to institute an appropriate civil suit to recover the title deeds or money that the appellants may have been constant to pay on their behalf. It needless that both the banks should be parties to this. Nothing in this order impinge upon the appropriate so and so. Now, this liberty was given when? This liberty was given the 2nd March 2020. Even within a period of 3 years, the suit was not filed. Suit was filed beyond 3 years. Number one. Number two, Milord, the writ court will not save the Milord the limitation clause. It is a liberty. Milord, the lordship is aware about this judgment. 2002 Calcutta High Court notes page 2007 volume 2 Calcutta High Court notes page 115. Division bench judgment. This is Milord Macintosh Bond Limited versus State of West Bengal. Yes. Milord, paragraph 23 and 24. The decision, even with 3 years they have not done it for leave aside. I mean, the decision of the Supreme Court in the case of Union of India versus Kirloskar pneumatic report in 1990 is clear on the point as stated. Even at the risk of repetition, it may be reiterated the Supreme Court in the state judgment, no uncertainty held that the power conferred by under Article 222 is designed to effectuate the law, to enforce the rule of law, and to ensure that the several authorities and organ of state act in accordance. It cannot be invoked directing the authorities to act contrary to so and so. 21. In view of the following, we have no hesitation to hold that the learned signature will dispose the petition under Article 220 along with granted liberty respect 4 and 5 to challenge the award and appeal about so and so. But such a liberty can in no way be interpreted to have directed the appellate tribunal to condone the delay in preferring the appeal if there is any. Therefore, injunction, I am limitation, leave aside. Even 2020 you are aware, when the writ court has filed, you have not filed. You are coming on 2023 even after 3 years. Because the judgment was delivered on 2nd March 2020. 3 years expires on 1st March 2023. Even suit has been filed on 9th March 2023.
Knowledge was a question.
And knowledge is, according to them, is 2002.
The last DP order,
Division bench order.
not to 2020.
Yes.
The division bench also has not granted Millard the any order. The limitation would be saved.
Yes.
These are my points.
My learned friend is resisting at the ad interim stage. But ad interim stage, he
He is only
limitation. But
concentrating on a point of limitation.
yes, now if he has to
We are conscious that so far as the merit or his case is concerned, he can't argue unless he file affidavit.
even on the question of limitations at the ad interim stage, if he has to make out a case that because of the plea of limitation the suit is barred,
Correct.
then his case has to be such a high case that from the reading of the plaint, he must
Correct.
be able to show
Correct.
that it is expressly time barred,
Correct.
not an iota of evidence.
No,
or
he can,
any
he
amount
can,
of
he
doubt.
can rely upon a documents also annexed with the plaint
Yes,
or with the
there is
injunction
no doubt.
application. There is no difficulty.
No difficult. Now, my suit, if your lordship reads the plaint, your lordship will see my suit is based upon a revelation of fraud, based on which I am saying that money has been paid by me under mistake, and now it has revealed to me that there is an element of fraud which has been practiced in bringing into existence certain documents on the basis of which they have taken the money. Now that FRT is only used here to give me knowledge. I do not say that FRT is that high a piece of document by which I am getting a decree. I am only saying that this gives me the knowledge. And my lord, cause of action, my learned friend relied upon paragraph 90 of the plaint. Cause of action is not one piece of fact. It is an entire bundle of facts based on which I am seeking my relief. That is why, my lord, the first sentence of that paragraph says that when I paid the money and got the release of the title deed, that is the first accrual of a cause, because I have now got back my title document. At that point of time, I cannot, and I have not made out a case of fraud on the basis of that document, because I know nothing about that document. It is only if your lordship sees my FIR, which is also a part of the plaint, even on the FIR, I say that I do not know how come several title documents have come into existence in respect of one property. This is a matter which needs investigation. So I do not say that I am aware that this is fraud. I make an allegation of fraud, but only when the FRT and an opinion is contained therein. That gives me a knowledge that there is a prima facie opinion of fraud expressed by an expert whose name is mentioned there. So that is under section 17 of the Limitation Act. My lord, I base my cause of action to get the money back ultimately on this document. That is, my lord, what is section 17 saying of the Limitation Act. Where in the case of any suit or application,
Yes.
17(1), my lord, where in the case of any suit or application for which a period of limitation is prescribed by this act, suit or application is based upon fraud of the defendant or the respondent or his agent. B, C, and D, my lord, I am not coming. The period of limitation shall not begin to run until the plaintiff or applicant has discovered the fraud. So it is the case of discovery, not before a report is filed by the police authorities, or the mistake, or could with reasonable diligence have discovered it. But if I have waited even after the final report has filed, then I would not have crossed this bar, because my discovery by reasonable diligence is that document. Before that document, there are title deeds, but nowhere there is no fact or circumstance giving me the knowledge that this is fraudulent. So, my lord, the entire plaint has to be read as a whole for the purpose of challenging it on a demurrable ground of limitation. Just because there is one sentence that I have come to know on 2012 cannot make it expressly time barred. Because cause of action is not the release of the title deed itself. Cause of action is release of title deed coupled with discovery or knowledge that the loan guarantee documents and the title deed is forged.
Article 56 of the Limitation Act also.
Yes, sir. Yes, sir. When the issue or registration, if your lordship sees, third column, when the issue is the document is fraudulent,
Registration becomes
known to the plaintiff. So, my lord, that is what I am saying. My lord, if your lordship kindly takes the plaint which my learned friend has placed at paragraph 35. I am saying that first arose cause of action, as I said,
page.
page, my lord, 91, running page 91, maybe 92 for your lordship. Paragraph 35. Cause of action of the instant suit firstly arose on February 16, 2012, when the plaintiff made payment of 1,46,00,000 to get back possession. There is no statement that I have come to know of the fraud or I have discovered the fraud. However, I have explained, at such time, neither plaintiff nor predecessor in interest of plaintiff had any evidence to prove that his father had never executed any document of guarantee or had created any security with respect to the property, and hence had no legal right to sue for recovery. Upon the New Alipur case being closed upon filing of FRT and cause of action revived, it was found that the purported deed and loan guarantee was paid by the plaintiff to get back the portfolio were forged. So, my lord, I am relying upon that document to get a knowledge. Nothing more, nothing less. But even the division bench order, if your lordship sees, division bench order creates a right for me only when, only it says only after investigation is completed. Division bench order does not say that the right has already crystallized upon me. Even then, even if a division bench order had said, it is still subject to the provisions of law. Whether a suit which I file is at all maintainable. Suppose I had crossed 3 years from the date of this report, then the division bench order would not have helped me. If a division bench order is only a tool in my hand to be used if the report gives me any knowledge about fraud. Nothing more, nothing less. So, my lord, my submission before your lordship, insofar as this stage of the proceeding is concerned, is that the learned court below, another important fact, my lord, which I had mentioned at the time of moving the appeal, had granted leave under section 12A of the Commercial Courts Act. It was therefore an opinion of the learned court that the suit which was filed contemplated urgent interim relief. Why? Not dehouse the plaint. Plaint contained these statements.
My judgment is contrary to what you say.
No, I am saying that even thereafter, the court can consider.
Can't take advantage of the leave. First, my judgment is there is no question of any leave to be obtained under section 12 capital A of the Commercial Codes Act. Section does not contemplate such leave. Second contention, my judgment is that it does not say that the moment there is a contemplation for an urgent interim relief, the court is bound to pass an urgent
No,
interim.
I am not saying that. That is not.
Thirdly, I have held that, rather we have held that even if the court, after considering the application for urgent interim relief, does not find that it is so urgent that immediate an order is to be passed, does not invalidate the institution
Of the suit.
of the suit, nor invite the rejection of the plaint on that ground, the moment the plaint contemplates or revealed an urgent interim relief. Because granting of the urgent interim relief is a discretion of the court,
Absolutely.
and
Absolutely.
depending upon the facts of each case.
Facts of each case.
I have said that the legislatures must take care of this situation. And as suggested by the Supreme Court also in a subsequent judgment,
Patil automation.
Patil automation, that the legislature should revisit
This,
and make a suitable amendments in the Commercial Codes Act. So we have also said that taking that clue, it is ardent duty of the legislature to take note of all these facts and then to suitably amend the provisions. The moment the plaint contains an urgent interim relief, whether it is to be granted or not to be granted, 12A can be bypassed.
Now, my last submission was this, that.
So you can't say that once the leave
No,
has been granted,
that is
so
not-
there is an urgency.
that
The
is
court
not-
has
that is
thought
not my
there
case.
is an
That is not my
urgency.
case.
What have
My
you done?
case is this, that even after knowledge of the fraud, I have pleaded why I have come now. I could have still waited for 3 years to pass, but I had come now because the entire fixed deposits which have been held by them, they have mortgaged it again to another private bank, Karur Vaisa. So it is on this basis which your lordship considered. And these are the these issues, whether we can rely what is the evidentiary value of this FRT, that is subject to trial. To what extent I can prove the forgery. And last point, Lord, that whether I have filed a Naraji or I have not filed a Naraji, I do not want to make them criminally liable at the most. But that document which is being said, that loan of guarantee, that is a forged document. I can always get a declaration from the civil court to be declared it forged, and consequentially I can get release of this money. So therefore, my lord, the cause of actions are different for a criminal action and a civil action. But the document of the police officer can be used only for the purpose of showing that other than that, I did not have knowledge. I may be in the air suspecting something, but nothing to come and tell the court that this is an opinion which I can rely upon and prove now. So, my lord, my submission before your lordship, my lord, let these issues be placed before your lordship by way of written objection. Your lordship will hear out the matter. Your lordship will continue the injunction till your lordship hears out the matter.
Injunction is till when?
Tomorrow, 15th of June. June. These are because these are demurrable issues. Your lordship can vacate an injunction on a demurrable issue, but the demurrable issue is to be tried on the test of a plea of demurrer. That only from the plaint it is ex specie barred. Otherwise, my lord, your lordship's prima facie view, which your lordship has already found, that has to continue. My perspective.
But so far, my understanding or interpretation in the super section 17(1) is concerned. What my learned friend has said. Kindly say. The question is, according to me, by the case of so A, the suit or application based upon the fraud of the defendant respondent. What my learned friend is submitting, if it is accepted, then I have to read the suit or application based upon established fraud. Knowledge of fraud and established fraud is different. And similarly, Millard, the knowledge of right to title of the application founded is considered as fraud. Established or knowledge. Knowledge means latest knowledge. Millard, Justice Division Bench judgment, Justice presided by Justice Banerjee, 2002 ever, that has been pointed out. Second, documents were delivered to. Last one is 2017 when the complaint was lodged. It's a forged fraud. There were difference between information of fraud and established fraud.
Yes.
And so long they were not required, they did not come approach, they did not get any protection. Why after, if I take it 2002, which has been referred to the division bench judgment, why after 21 years? If I take it below 2012, then why after 12 years? If I take it 2017, why after 6 years? Even if I take it report in 2nd December 2020, why after almost 2 years and 6 months? And suit is for, Miller, not the declaration. It's a declaratory suit. Kindly similar to prayer. Suit a prayer. Kindly prayer, page 94. No, 93 in my page. It is not a declaratory suit in respect of the deed is concerned. A degree of rupees 3 crore so and so, as indicated paragraph 80 of the plain here now jointly and severely against the defendant number 1. But unless it is declared fraud by the civil court, not entitled to. First, the decree has to be obtained. That is, yes, deed is fraud. It's a product of fraud. That declaratory suit has not been filed.
Yes.
I am therefore I am opposing this entry model.
Yes.
And this is on the point of law. No, I am whatever I am relying upon from their documents. Nothing I have.
That I know. That is what I already said. That in an ex parte ad interim order, it can't be done in this fashion. Now, come. The matter is listed for extension of interim order. Passed on 20th of April 2023. By which the respondent number 1 was restrained from using, withdrawing and or dealing with the money lying in the aforesaid account. In the account held with the SDFC Bank to the extent of rupees 1 crore 46 lakhs for a period of 8 weeks from date or until further order, whichever is up. Though the aforesaid interim order was passed in presence of some of the contesting respondents who appeared at that point of time, but today the respondent number 1 appeared and raises a vehement objection to the extension of the interim order, ad interim order, which according to it was passed in their absence, and therefore to be construed as an ex parte ad interim order of injunction against the said respondent number 1. we have no quarrel to the proposition of law that if an ad interim order of injunction is passed by the court in absence of any of the contesting respondents, it would be deemed to have been passed ex parte against the said non-appearing party, even though the other party appeared before the court on the said date. The matter has a checkered history. And the facts discerned from the record is not only alarming, but daunting to us, having a larger impact on the functioning of the financial institutions, dealing with the public money. While advancing the loan to a person on the basis of a security being put, which subsequently discovered to be an outcome of fraud and or forgery. The sordid state of affairs can further be manifested when a FIR was lodged by the appellant with the police officials for investigation, which ultimately proved to be a mere paper, as the investigating officer, even after noticing the serious fraud and the forgery having been played, does not find sufficient material to arrive at the conclusion that there is a cognizable offense committed by the person named as accused therein. The final report revealed the closure of the investigation in absence of any sufficient materials found against the named accused, although the contents thereof revealed otherwise. Be that as it may, this court do not intend to intrude upon the domain of the investigating officer, nor vested with the powers to pass any orders and have to proceed on the basis of the said document and its evidentiary value in relation to a cause of action pleaded in the plaint. The appellant, the predecessor in interest of the appellant, at one point of time intended to sell the said property and entered into an agreement for sale with the intending purchaser named therein. One can visualize the mistake committed by the said predecessor, that upon execution of an unregistered document is styled as agreement for sale. The title deed of the property was handed over to the said intending purchaser. The proceeding came to be launched against the respondent numbers two by the banks, arraigned as respondent number 4 therein. Taking aid of the provisions contained under section 13 within bracket 2 of the Surfacing Act as the account of the borrower is a non-performing asset. A proceeding was initiated before the Debt Recovery Tribunal. Obviously, under section 17, it was 17.
Yes.
Under section 17 of the said act, impleading the predecessor as party therein.
By another bank.
It was all along the stand of the predecessor that they never executed any loan agreement with the bank, nor stood as guarantor, nor executed any documents in this regard upon deposit of the title deed, which was admittedly handed over to the intending purchaser, being some of the respondents in the instant appeal. Obviously, the moment the property is attempted to be encumbered.
When 17 was not done, 14, they got an order under section 14.
14, order 17 in jagah 14. Before the Debt Recovery Tribunal, I found it was there before the Debt Recovery Tribunal.
That is an OA was filed. 17 of the Debt Recovery Tribunal Act was filed.
It is what I'm saying.
I thought 17 of surfacing.
No, 17 of the Debt Recovery Tribunal Act.
Right.
I just said Debt Recovery Tribunal Act. DRT Act. ওটা অনেক বড় আছে, ওটা বলতে পারবো না। সারফাসিও বলতে পারবো না, ডিআরটিও বলতে পারবো না। 17. There is no provision under section 17 here.
19
19.
of the RTB Act.
Yes. 19. The stand was taken that there is no deed executed by the said predecessor, and it appears from the complaint being a part of the record lodged with the Deputy Commissioner of Police on 23rd June 2017, that a prayer was also made before the Debt Recovery Tribunal to investigate into the matter by appointing an handwriting expert. It is further indicated therein that because of the procedural obstacle faced by the DRT. The same was not done. And ultimately, on filing of the final report by the investigating officer, it was detected that the deeds forming the deeds sublime the advancement of the loan to the principal borrower were forced. To stop. Admittedly, the suit came to be filed for recovery of the money and the damages within 3 years from the date of the submission of the first information report. Stop. However, Mr. Bandyopadhyay, the learned senior advocate appearing for the respondent number 1, arduously submits that a plea of limitation which strikes at the root of the maintainability and the entertainability of the suit is required to be determined before the court embarked its journey on the peripheral of Order 39, Rule 1 and 2 of the court. According to Mr. Bandyopadhyay, mere using an expression fraud does not absolve the plaintiff from pleading when such fraud becomes known to him. And if the suit is not filed within a prescribed period of limitation, therefore, the court is denuded of power to pass any interlocutory orders in such incompetent and or invalid suit. It is a specific stand of Mr. Bandyopadhyay that all along the predecessor as well as the plaintiff was aware that a fraud has been committed by depositing the false title deeds, which would be evident from paragraph 35 of the plaint. More particularly, when the predecessor of when the plaintiff appellant paid the due amount to the respondent number 1 in order to secure the custody of the title deeds and to get away with the rigorous provision of section 13 within bracket 4 of the Sarfasi Act. The moment the aforesaid conduct is reproduced in the pleading, it is inconceivable that the cause of action for institution of the suit does not arise. Rather, the suit would have been filed within the statutory period of limitations, reckoning from the said date. as mentioned in the said paragraph. Apropos the aforesaid contention, it is further submitted that the findings made by the investigating officer, the findings recorded in the first information report by the investigating, in the final report by the investigating officer, is not a conclusive proof of evidence, nor can be used as an evidence in a civil proceedings, as the criminal proceedings stands on a different footing that of the civil proceeding, and therefore cannot form a basis of a cause of action for the purpose of limitation. The reliance is placed upon a judgment of the Supreme Court in case of Syed Askari Hadi Ali Augustine Imam and another versus a state within bracket Delhi administration and another reported in 2009 volume 5 SSC 528. Wherein it is held that if both the criminal proceedings and the civil proceedings are instituted on a self-same set of facts, primacy to the criminal proceedings cannot be given to a criminal proceeding. And the decision of the criminal proceeding may and therefore its interpretation does not arise by relying a judgment of the Constitution Bench of the Supreme Court in case of MC Mehta within bracket Taj Corridor scam versus Union of India and others, reported in 2007 volume 1 SSC 110. Lastly, it is submitted that even if the leave has been granted in one of such proceedings initiated by the appellant to institute a suit for recovery of the title deed as well as the money, cannot override the applicability of the Limitation Act, nor can be construed to whittle down its efficacy, as the court cannot legislate nor can put the applicability of the legislative provisions by using an judicial in a judicial fiat. We are not unmindful of the proposition of law that even if the court has passed an ex parte ad interim order of injunction against a person, such persons shall be deprived of such person shall not be shall be permitted to raise an objection even at the stage of extension of interim order, extension of ex parte ad interim order injunction. The court should not mechanically extend the ex parte ad interim order of injunction after the adverse party has entered appearance, but should record reasons after affording an opportunity of hearing to the said party. Order 39, Rule 3 of the Code of Procedure bestowed power upon the court to pass an ex parte ad interim order of injunction against the party, provided the court, by recording reasons, is convinced that the delay in passing such an interim order would defeat the very purpose and would cause immense injury to the plaintiff or the appellant. Such rule is an exception to the normal rule that the court, before passing an ad interim order of injunction, must give a notice to the defendant and after affording an opportunity of hearing, should proceed to pass an order. The recording of reason is an important facet of dispensation of justice. And the court should be slow and circumspect in dispensation thereof. However, it is to be noted that the moment an oral submission is advanced by the adverse party against whom an ex parte ad interim order of injunction is granted, before filing of an affidavits, the confinement should be with the pleadings made in the plaint as well as an application for injunction and the documents annexed thereto. And such contesting defendant should not be permitted to bring a new document unless the same is brought on record by way of an affidavits. In the event the said party convinced the court that the existence of the materials and or the pleadings does not invite the court to invoke the exceptions carved out under Order 9, Rule 3 of the Code. Start করেছি কিভাবে? কি বলেছি? Even? Oh yes, correct. Even? The court may refuse to extend the ex parte ad interim order of injunction. by recording a proper reasons. Precisely for such reason, next paragraph, precisely for such reason, we permitted the respondent number 1 to make submissions. And in fact, the said respondent has restricted the submissions on the basis of the pleadings of the appellant and the documents relied upon by him being a part of the record in support of the contention that the instant case does not warrant extension of interim order. The plea of limitation is certainly a plea of certainly a plea based on a statutory provisions. And therefore, it is imperative on the court to consider the same. The object and purpose of incorporation of the legislation relating to Limitation Act can never be construed to deny to destroy the rights of the parties, but has an applicability on the reliefs and the remedy sought before the court. In other words, the Limitation Act does not take away the rights of the parties nor extinguish the same, but denies the relief to either of the parties from the court of law if the party does not approach the court within the prescribed period of limitation provided therein. The moment the plea of limitation is taken at the nebulous stage of the suit, more particularly at the interlocutory stage, the court must confine its consideration whether the pleadings justify the pleadings whether the pleadings on the face of it debars the relief from the court, having fallen within the mischief of the provisions contained in the Limitation Act. The plea of limitation is both of fact and law. Sometimes such plea is regarded as a plea of law simpliciter, but sometimes it is construed as a mixed question of fact and law. In former case, there is no impediment on the part of the court to arrive at a definite conclusion from the materials available from the record that the reliefs claimed is expressly barred by the provisions of the Limitation Act. But in a latter case, the court can only arrive at such conclusions after full-fledged trial. Therefore, it is an ardent duty of the court to ascertain the nature of the applicability of any of the provisions of the Limitation Act in juxtaposition with the pleadings and the stand disclosed by the parties, discernible from the materials put on record. It admits no ambiguity in our mind that the moment the court found that the plea of limitation is required to be decided on the basis of an evidence to be adduced in this regard by the plaintiff, such plea should not be decided at the interlocutory stage, nor to nip the proceedings in the bud, but should postpone the determination thereof to be decided as an issue in the suit upon the party having undergone the trial. Full stop. Such being the proposition of law as understood, we have no hesitation in our minds that the plea of limitation can also be taken at the interlocutory stage, provided it is not a mixed question of fact and law. The applicability of any of the provision of the Limitation Act has to be seen in conjunction with the pleadings of the parties and the cause of actions. Disclosed therein. The expression cause of action has neither been defined in any statutory, in any statute, nor there is neither is not defined in any statute, but received its definition under the common law and by different judicial pronouncements. The cause of action cannot be said to be a stray date or the place, but is always regarded as a bundle of facts required to be pleaded by the plaintiff, inviting the court to determine the dispute and to grant reliefs as claimed therein. It would not be a safe course for the court to concentrate on a particular paragraph of the plaint where the cause of action has been succinctly jotted down, but to read the plaint as a whole. And upon assimilation of those facts, to ascertain the cause of actions, discernible therefrom. The cause of action can never be squeezed into a straitjacket formula nor should be regarded as a Pythagoras theorem, but the disclosure and/or disclosure of the facts in the pleading by the plaintiff, raising an issue or a dispute capable of being determined, capable of being decided by the court. We are also not unmindful of the fact that every fact may not constitute a cause of action, but those relevant facts which are necessary for being adjudicated, having been proved by the plaintiff, and have a nexus to the remedy and/or reliefs claimed in the plaint. Next paragraph. The plaint proceeds that the appellant and the pro forma respondent number 3 are the owners of the premises number 37B, block B, New Alipo, Kolkata 53, having inherited and succeeded the same from their father, who was an admitted owner thereof. An agreement for sale was executed between the father and the respondent number 5 and 6. For sale of the said property, and an original title deed of the said property was also handed over to the said intending purchasers. Stop. Subsequently, the dispute cropped up between the parties, and a criminal proceeding was launched, which ultimately traveled up to this court. Subsequently, it was noticed that the UCO Bank, subsequently the UCO Bank issued a notice under section 13(2) of the Sarfasi Act upon the father, alleging that he has mortgaged the said property and stood as a guarantor for a loan advance to one Tirupati Textiles. Immediately the writ petition was filed. Where the said intending purchasers appeared and unequivocally asserted that they are in possession of the title deed. And on the basis of an order passed in the said writ petition, no, sorry, on the basis of the Kibolichi, is with them, full stop. Title deed is with them, full stop. Subsequently, an order was passed in the said writ petition restraining the bank from taking any steps in respect of the property and relegated the father of the plaintiffs to take steps before the DRT. Simultaneously, the DRT also restrained the UCO Bank from taking any further steps of parting or dealing with the said property in dispute. And directed the deposit of the said deed with the DRT. Full stop. Subsequently, a suit was filed by the predecessor of the plaintiffs before the civil court, before this court, wherein an ad interim order was passed against the DRT not to release the original title deed of the property without the leave of the court. However, the said suit was ultimately dismissed for default. But it is alleged that during the subsistence of the said interim order, the possession was taken by the respondent number one. The possession of the property was taken over by the respondent number one. Subsequently, the steps under the Sarfasi Act was taken. And it is pleaded in the plaint that an offer was made that if the predecessor of the plaintiff's deposit is sum of rupees 1,21 lakhs and paid a sum of rupees 25 lakhs in cash as a cost of incidental or expenses, the property would be released. The said amount was paid aggregating to rupees 1,46 lakhs. And the no objection certificate was issued through a letter of the respondent number one dated February 16, 2012. Subsequently, a police case was registered in the year 2017. Under section 120 capital B / 467, 468, 469, 420 and 471 of the Indian Penal Code. And an investigation was contemplated. Since the investigation was proceeding in a slow pace, the plaintiff approached this court, invoking the provisions contained under Article 226 of the Constitution, wherein this court directed the investigation to be completed within a stipulated time, which would be regarded as peremptory, and further granted granted liberty to the plaintiff to institute a suit for recovery of money or the deed before the civil court. Pursuant to this direction of the writ court, the final report is submitted on December 2, 2020. Recording the facts unearthed during the investigation as succinctly narrated herein above, but ultimately no cognizable offense was found to have been committed by the persons against whom the first information report was lodged. The said final report would reveal that a forced deeds were deposited with the bank to secure the loan, and the documents allegedly containing the signature of the father of the plaintiff was found to be forged by the handwriting expert. Admittedly, the suit is filed within 3 years from the date of the submission of the said final report, which according to Mr. Bandopadhyay, the learned senior advocate, cannot be regarded as a starting point of the limitation, as the plaintiff was all along aware that the deed is a forced one and a fraud has been committed. Stop. Section 17 of the next paragraph, 17 of the Limitation Act postulates that in a case of any suit or an application for which the period of limitation has been provided in the said act based on fraud of the defendant or the respondent or his agent, the period of limitation would not begin until the plaintiff has discovered the fraud or the mistake, or could with reasonable diligence have discovered it Article 56 thereof provides a period of limitation of 3 years in relation to a declaration of forgery of the instruments. And the time of the time from which such a limitation would reckon shall be when the plaintiff becomes known of such forgery of the instrument. Mr. Bandyopadhyay, the learned senior advocate, is very much critical on the expression fraud, as according to him, fraud cannot be construed as an established fraud. For the purpose of computation of the limitation under section 17 of the Act. It is no doubt true that the court shall not add or subtract any words or expressions in the statute. But its primary duty is to interpret the provision as exists in order to render it workable and not redundant or osseous. Subtraction and or addition of any words in the statute to cull out its meaning cannot be resorted to if the language employed therein conveys a definite intention of the legislatures and the purpose it sought to achieve. The fraud used in the aforesaid section has to be understood in the perspective of the Buini. Ashurjo. Civil Contract Act. They have the copy of the Contract Act. In a civil bench, there will be no Contract Act. Not believable.
I got a book here. Harish.
Section 15. 17. the fraud defined in section 17 of the Indian Contract Act 1872 in a civil proceedings. Full stop. Has to be construed, bolechi to, in the perspective of the definition of the fraud under section 17 of the Contract Act in the civil proceeding, comma diye, in the civil proceeding. Contract Act for comma diye in the civil proceedings. Full stop. The fraud has a varied form. The fraud has a varied form and therefore is to be ascertained, and therefore particulars of the fraud is required to be pleaded in the plaint. The plaint would reveal that the fraud is not only played on the plaintiff, but also the banks, but also upon the banks who have lent and advanced the loans to the borrower therein on the basis of the documents which prima facie found to be an outcome of forgery. The plaintiff appellant have also relied upon a letter caused to the Deputy Commissioner of Police on 23/6/2017, alleging the fraud, perjury, preparation of false documents for the purpose of cheating, false declaration before the court of law, so on and so forth, wherein it is indicated that a thorough investigation is required to be made by the Central Bureau of Investigation relating to the fraud having been committed, fraud committed by the alleged borrowers. To stop. It is further indicated that though the debt recovery tribunal also felt that the thorough investigation is required to be made, but because of the legal impediment, refrained from doing so, and therefore did not come to a specific conclusion regarding the fraud or the forgery in relation to the title deeds of the property. The said complaint would further reveal that the Central Bureau of Investigation has caused an investigation in respect of a different offences by the officers of the bank, but has not arrived at the definite conclusions in relation to a subject property. The plague to further reveal that the moment the final report is submitted, wherein the investigating officer opined that the title deeds used for securing the loan, title deeds were forced. The suit came to be filed within a period of limitation to be reckoned therefrom. It is no longer a centigra that the judgment of the criminal court has no impact on the civil proceedings, nor any primacy should be given to the criminal proceedings over the civil proceedings, as held by the apex court in Shayyad, Askari, Hadi, Ali, Augustine, Imam, and others, within bracket Supra, in the following, paragraph 24 take quote, 24 and 25 take quote kore daw. We are not unaware of the proposition of law that the findings made in a criminal proceedings may not be binding on a civil court, but the converse is true. There is no decision that has been taken by the criminal court as the final report closing the case was simpliciter accepted and no further order was passed thereupon by the concerned judicial officer. The question of its legal efficacy and the nature of its binding effect in the civil proceeding has to be determined at the time of final disposal of the suit, inviting the parties to adduce evidence in this regard. We also do not find any quarrel to the proposition of law enunciated by the Constitution bench in MC Mehta, within bracket Supra, that the term investigation appearing under section 173 within bracket 2 of the Code of Criminal Procedure is an expanding, has an expanding, is expanding and includes opinion of the officer in charge who conducted such investigations in relation to a sufficient evidence or reasonable ground for cognizable offense. Certainly it does not have, certainly such opinion is not a legal evidence, nor the court should form its decision on the basis thereof. However, it can be regarded as an information or the knowledge of the fraud or the forgery only for the purpose of the limitation and not otherwise. The limitation in relation to a case based upon a fraud or a forgery would reckon only from the date when the such fraud or the forgery is made known to the plaintiff. The pleading on its meaningful reading would reveal that the plaintiffs were skeptical about the commission of a fraud or the forgery, though they all along asserted that no documents were ever executed by the predecessor, nor them in relation to a loan given to the third party, nor the title, nor the property was put as a collateral security. Full stop. It is thus an essentially it is a mixed question of fact and law, depending upon the quality of evidence to be adduced by the plaintiff, and cannot be said to be an apparent case of coming within the mischief of the provision of the Limitation Act, so as to disentitle the plaintiff to maintain the suit. The plaintiff to maintain the suit. We thus do not find that any definite conclusion can be made over the plea of limitation at this stage, and therefore said issue is kept open to be decided by the court after full-fledged trial. Stop. Since no other point was raised.
Another one point I that the 13 years have gone to the
That's the plea of limitation.
not apart from limitations. Interim order is not taken.
Next
Time. balance.
a ancillary point is taken that the plaintiff was appellant was silent for a period of 13 years, having detected that a loan has been advanced to a third party. Upon keeping the property as a collateral security, the court should not have proceeded hastily to pass an ex parte ad interim order of injunction. Hastily pass an ex parte ad interim order of injunction as
Do not use by expression.
the question of balance of convenience and irreparable loss and injury does not tilt in favor of the plaintiff. It has been stated in the said application that taking advantage of the situation as prevalent, as well as squandering the money from the jurisdiction of the court by the respondent number 1, which in our opinion invites an immediate and interim protection to be granted. As such situation is invited as pleaded in the application for temporary injunction. To stop. The moment we found that the parties have entered appearance, we feel that it would be opposite, that they should be allowed to exchange the pleadings before the court arrived at the definite conclusion whether an order of temporary injunction should be granted or not. We thus extend the interim order passed earlier for a period of 8 weeks from date or until further order, whichever is earlier. The respondents are directed to file affidavit in opposition to the application within 2 weeks from date. Reply, if any, shall be filed within a week thereafter.
3 weeks.
The application is made returnable 3 weeks.
3 weeks.
3 and 1, 4. 3, 1, 4.
3 and 2, my lord.
Not 2.
Returnable here.
3, 1, 4. You also file. We say respondents. We did not say respondent number 1. All the respondents shall file their affidavit if they chose.
Returnable 4 weeks.
And actually, this injunction is against respondent number 1 only. So if you chose, you can file.
Interim order for 8 weeks and returnable 4 weeks.
This is what he says.
All right.
Thank you.
Development.
এখানে কন্ট্রাক্ট একটা এখানে রেখে দিতে হবে। কন্ট্রাক্ট একটা এখানে ছিল অন্য কারোর বই, একটু দিয়ে দেবেন। হ্যাঁ, করে দেয়, কারণ ওরা সুপ্রিম কোর্ট যায়, তাই জন্য সবটা নিয়েছে।
না দেয়নি, চেঞ্জ করে নিতে হবে। এই তো প্রবীণ কি কোথায়? প্রবীণ কোথায়? দাগ দাগ বাইরে কি করছে ওরা? এগুলো কার? এগুলো আপনাদের তো? এটা কার?
part of the life, part of the profession.
It was beyond my control.
কি আজকে আজকে তো আর কি করা যাবে? তোর কি তোর একটা ফিস দিতে হবে আমাদের ভয় পাচ্ছিস? 3:30 আছে। আমি বলে দেবো কিছু আসবে My lord, I have placed, my lord, all the provisions of law dealing with the matter. Only one copy I could not have handed up to your lordships. I am giving it and I will be just placing that one. The recruit, my lord, rules framed by the commission. Then I will be making my submission and cite the judges. My lord, this is your lordships. Kindly consider West Bengal School Service Commission selection of persons for appointment to the post of teacher rules 2007. My lord, before 2007, because 1997 School Service Commission came into effect, my lord, there was only on the basis of merit panel was prepared and according to the vacancy available, name was sent. My lord, there was no provision for anything except because for the first time 2010 mutual transfer came. If anybody wanted to shift any other district, he had to sit again the examination and then he could have according to a choice. That was the procedure. Now your losses by this procedure, kindly see my lord, rule 17. Down. না এটা মানে by the concerned regional commission during counseling for exercising option for selection of school or madrasa as the case may be by the candidates at the material point of time as per his choice. Not all that I'm trying to show your losses. Therefore, my lord, on the basis of merit, ranking, position in the panel, I have a right to choose the school subject to available of vacancy. So this is, my lord, all that I'm trying to, this is a school specific on the basis of merit. There was no transfer provision in either of the act and rules. Now, two things I just, my lord, tell your lordships. First, your lordships, I have, my lord, taken your lordship, my lord, I will stand corrected. We have tried our best. My lord, this notification has not been subsequently gazetted appointing the date of coming into force.
That was the first one.
First one, page
That
42.
amendment, that
Page 42.
amendment which was brought.
My lord, page 42 of the bunch of the,
Yes.
that's your loss, the first one. This is notification published on 17th April 2017 to appoint teachers, not including institution that. Page your lordship 42 and 43. So this gives the power to board to appoint. If this is not, my lord, appointing date is not gazetted by notification, so our appointing authority remains the managing committee. That's one thing. Now, other two, I tell your lordships. Well, if it is not, if cannot be, if it is, it can't be answered, my lord, that there was no gazette notification, then I think, my lord, entire thing goes.
No, Mr. Sanal, the position is different. Whether they have a power or they do not have a power or whatever, these all relates to a merit of the case where the question would be that whether the state government reserves the power to transfer or does not reserve a power to transfer, whether the board is the only competent authority to transfer or a managing committee to transfer. That is the only thing. Whether 10C, the question is whether 10C is a constitutionally viable provision or it cannot be said to be a constitutionally viable provision. Question of these are all relating to a merit, the competence of an authority to effect the transfer. So that will be decided in the writ petition. The court may ultimately arrive at all these conclusions and will say that yes, by virtue of this, the power is not vested upon the commission to recommend for the transfer. So hence the order of transfer issued by this authority, who is incompetent, cannot be said to be illegal and valid. That's one aspect. That's the merit. We are concerned with the incorporation of 10C, whether it offends any of the provisions of the Constitution, whether, may I use the term, whether we can use the Wednesbury's principles, which is one of the facets on the test, on the touchstone of reasonability, whether we can go into that. This is what we have to consider.
Now, if your lordships, my lord, consider from this angle, if an power, suppose your lordships hold this is inter vires. Suppose. Now, if the power cannot be exercised by the ultimate appointing authority, ultimately transfer has to be done by the board. If the board doesn't have any power, then your lordships, the entire exercise is in futility.
That is a different issue.
Entire exercise is in
That is a
futility.
different issue.
So your losses may not, my lord, go into all other things.
There are two aspects: that conferment of power upon an authority, which appears, according to you, which appears to be in conflict with the corresponding the statutes. Then you'll have to say. Then which statute will have the primacy if they stand on a specific sphere and there is no question of any overlapping? Then why?
Now your losses kindly consider the, my lord, kindly keep it in your losses mind.
No,
I'll
that is
enforce
true.
that.
What you are saying is really going into the merit of those orders of transfer.
Order of transfer has not yet been issued. All are recommendation except one or two.
Whatever the recommendations or order of transfer, whatever.
Now your losses, this thing and the other your losses kindly consider the I placed before your losses that I have not informed your losses yesterday. Rule 1969 I placed before your losses. Rule 28 I placed and rule sub rule 7 of rule 28. Now that your losses will get it just for my lord, second your lordships. Kindly consider that because this is factual that I have to place it. Page 56, rule 28. This power to appoint was with the managing committee by the notification dated of April 2017. This goes to the board. 28(1).
Correct.
Yes. This has been deleted. As soon as that notification was published, in March 20, this power was taken away from the managing committee.
Correct.
Similarly, your lordships kindly consider page 58,
Yes.
sub rule 7. This I have not placed before lordship, not in.
They are placed.
No, I have placed, but this was taken away by a notification. This was deleted from the rules. That I have not informed your
Yes.
lordships. Sub rule 7 also.
Correct.
So that there may not be any misunderstanding that I have not placed.
There is
before
no
lordships.
ambiguity in our mind. Don't worry.
I have not placed this fact that this was also deleted.
Yes.
But this was our right and we accrued the right at the time of appointment. These were my conditions.
Oh, if I really summarize what you are arguing is that look, by a different provisions, initially the power was conferred upon the managing committee not only to appoint but also to select the candidate in relation to that particular school. The moment you say that these procedures were adopted, that implies that it was always a school-centric appointment because the vacancy was published by the managing committee of the school in relation to that school, and therefore the concept of transfer was unknown. Means a person born in a institution and die in the institution.
Exactly that.
In a very blunt manner, if one can say.
No, certainly, Lord.
True. So this is what your concept was. Now there has been a radical changes by different appointments. The School Service Commission Act came in 1997, where
There
some
had
kind of
one
a-
point.
some kind of a
If
factor was
even
made.
even after School Service Commission, that situation did not change.
No, no.
Initial,
Yes.
my lord.
What was the object of the School Service Commission? Object was that they have to take overall situations or a stock in relation to a state. And thereafter, even a selection was bestowed upon them.
Only selection and recommendation.
Suitability, selection, everything was conferred upon the School Service Commission. They were regarded as a recommending authority. But the appointing authority would remain because
The school.
initially it was a managing committee. Thereafter, it is shifted from a managing committee to a board.
But that's the impugn notification. That's not impugn. That's one of the notifications.
Now, so far as the appointing authorities are concerned. Now, what is the recommendation done by the Service Commission?
Now,
Recommendation is that I hereby recommend that this particular teacher, maybe assistant teacher, headmaster, or whatever, is to be appointed in a school. Initially, there was no concept of counseling. The concept of counseling came later on. 1997, when this act was introduced, there was no concept of counseling.
no counseling.
It was introduced subsequently. The counseling which I perceived was in order to bring more transparency, fairness into a system, that a person must know that where he is moving.
But that was equally earlier also.
No.
I tell you, losses, unless some.
It was within the exclusive domain of the commission. He chose here in this school, he will go, he will sort out where he must go, where he will be suitable, where he can be placed. That was there.
No, on the basis of ranking.
No.
Somebody plays something else, that's different.
What is the ranking? Ranking is remained, but the posting when
No, I tell you,
is different.
what this is still
It is
goes on.
different.
This still goes on in College Service Commission.
Yes.
That's illegal.
That recommendation is a different for posting.
That's
There is
my
no-
case.
there
This
is no
college school
gradation.
specific.
Please kindly, there is no gradation of the school.
No
As on
gradation.
date. That I have given a gradation. This school, the educational institution stands on the first position. Best school in the state. Second ranking, third ranking, fourth ranking, and so on so forth, which is usually done so far as the, the technical colleges are concerned. Even all over the world, even globally, there are certain, the organization or the institutions or whatever, they rank those universities of the world, that these are the best universities in this medium, in this field. They are number 1, 2, 3. And then on the basis thereof, the students or whoever wants to get an admission, if he has ranked very fairly high, he would choose the best rank institution because he wanted to pursue a particular, the curriculum or whatever, the subject. And in that subject, that university is ranked as number 1. So he wanted to pursue study. There is no difficulty. That was not there. There was no ranking. Maybe suitability, the commission, maybe on the hindsight, was thinking about that we will see he's a meritorious person. There is a school already near to his house. Let us recommend that he should be posted in that institution. This was done randomly, maybe some consideration, which is not neither here nor there. I believe Mr. Patro will agree with me.
Initially, when there was no system of counseling,
Correct.
then the commission would choose the school and.
That is what I am saying. That was it I am saying.
Followed was the address of the applicant.
Correct. That is what I am saying.
That's the,
That was the consideration. That somebody near to his house, fairly ranked fairly well, he should be given that. Not provided. If he has, I think in the teacher examination, subject-wise you
yes,
chose.
subject wise,
Now suppose in a
Subject-wise,
nearby school,
medium wise.
he has done it in a geography, he is supposed to be posted to teach geography. He can't teach mathematics.
No, certainly.
He can't teach the physical science or the physics. So if suppose there is no vacancy in the post of a geography in a very nearby school, say at the very close distance, he cannot be posted there.
No,
Subject to vacancy.
Unless vacancy is there, no.
But the endeavor would be a nearby. One must be within 1 kilometer, another school which is found which is in 5 kilometer. Vacancy is there. So posted in a 5 kilometer, that may be just is a presumption, I tell you. I do not know whether it was really rigorously followed or not followed. Favoritism, nepotism, whatever. I do
That
not
is
want to
always
enter
there.
into
That's
those
not
aspects.
neither here nor there.
I
That's
do not
always
want
there.
to go into those. That was not there. But after the introduction of this counseling system, now it has shifted from the domain of the service commission to a candidate itself. That his initial appointment has to be there if he chose.
Malad, mind it, Malad. Even then, there was no provision for transfer in the service condition.
The question is, there was no transfer provision. Now the transfer provision has been introduced gradually in 3 phases in the 1997 Act. If I correctly understood, the first one was Section
Mutual
10A in 2010. Nobody till date challenged that particular provision. So acceptance is there that yes, transferable.
No,
I'm susceptible to be transferred. Forget about it. If there is no concept of transfer, there cannot be any concept of joint application or joint transfer. Transfer has to be erased or effaced completely. You can't be choosy. That I choose one which is beneficial, I will accept it, embrace it. One which is a bit prejudicial, disadvantageous, I will not choose it.
no, unless law permit me.
Law does not permit. If the transfer is not permitted, then even a joint transfer is not permitted. No transfer.
Malad, I would request your law.
Transfer at all.
I would
You
request.
have to stick. You have to remain there. You can't choose that I should be placed somewhere else. I want to go there. It so happened because when somebody got married and the in-laws are in a different district, obviously the difficulty arises. They may choose that if there is a transfer, I may go so that at least I can have good. But you say that there is no concept of transfer, then there cannot be any concept of mutual transfer. There cannot be any concept of,
My lord, even then that is in the year 2020. My lord, at best, my lord.
absolutely, transfer money, transfer হবে. Under no circumstances transfer.
My lord, I will be, my lord, making
Then
facts.
10A, 10B has to go.
Let it be
altogether.
gone. My lord. That's one aspect. My lord, I tell your lordships, why, my lord, this has been introduced by the government for its own benefit.
What benefit?
I benefit, I tell your lordships. There were, my
Not
lord,
own benefits, sir. You have to.
my lord,
be
had,
very
government
choosy
had
about the
benefits.
language. No,
Government had, I tell your lordships.
own benefit does not mean government does not have any religion. The government does not have any kind of a benefit.
I tell your lordships.
It is for administration and it is for governance.
My lord,
That's all.
when transfer becomes a condition of service, when it is a right of the employer to transfer him. When it's a provision gives me a benefit, that's not a, my lord, condition of service.
Huh?
I tell your lordships. I kindly allow me to kindly think over it, your lordships. Because kindly consider section 10 of the Act of 1997.
I have held otherwise.
My lord, your lordships, my lord, kindly consider it, my lord, afresh. I tell your lordship, because mutual provision for mutual transfer was
Sir,
not in the statute.
I have held in a DA case that the moment the government has taken a decision to give this DA to the employees, though they are not bound, but they give and introduced in the statute system, then it becomes a right of the employee to get a DA. It becomes a part of the condition of service.
Now your losses kindly consider this.
Now
My lord,
consider what you say is that it becomes a part of the condition of service. You can't thereafter say, I will lift it.
my lord, that's your losses beneficial to the employee.
I'm saying, whatever, that means you want to make a distinction, a line of, apparent line of distinction. Whatever the government gives, which is beneficial to me, yes, becomes a
That's why I
part
said
of the
if
condition
law
of service.
permits me.
And whatever a little bit disadvantageous to me does not become a part of
That's your
my
loss, because this was not in the initially. This was not initially.
You are reprobating and approbating at the same
My
time.
lord, reprobating, approbating, if it is the same thing. Mutual transfer and compulsive transfer are not the same thing. Mutual transfer benefit everybody cannot take, but compulsive transfer can be imposed by the government in respect of all. And that, my lord, section 10 comes into play. Disadvantageous. No, these are the facts, your losses, my lord. Provisions of law, and let us, my lord, in my own humble way, my lord. No. ওরকম কেন?
এই যে প্রভিশন ছিল না সেটা কিছু
No, my lord, the first, my lord, I just, my lord, one after another point I have said, I just advance and cite my judgment in, my lord. The first point, your lordships, if your lordships consider section 10C, my lord, it straightway gives, my lord, the power of the state, power to the state government to transfer. If you lordships see the language, 10C, straightway. Kindly, your lordships.
Two grounds. In the interest of the administration
That's
and in the interest of the public. These are the two
my lord,
elements.
I tell your lordships, in my service condition, there was no provision that I may be transferred. I'm trying to make it to distinction.
Oh, that's why I said, Mr. Sanyal, please, again, I'm repetitive. It is one thing to say that the provision is not applicable to my service. And it is absolutely different to say that this provision cannot stand in the eye of law. The provision should be absolutely deleted.
That's
from the
I'm
statutory book.
explaining.
You say that so far as I am concerned, this, because there is no condition attached to me, to my service relating to transfer, so 10C will not apply to me.
No, that's
There's a merit.
Malad, this is one of the submission at last. But your lordship, what I'm trying to say, your lordships, this act straightway gives the power to the state government to direct commission, to recommend for transfer. This power, Malad, is not according to the object of the statute. Object of the statute to select me and recommend. This is my first submission. Therefore, this provision itself, my lord, ultra vires of the statute. Eta judgment. Eta. 1998. Yes. I submit before your lordships. Recommendation can only be made for appointment. Now, transfer is a subject for the employer. Employer, your lordships, if your lordships consider the amendment of the rule now, the board. So board has to.
But according to you, so far as this power has not been.
That's your lordship. That has to be, Malad, state has to answer because we have searched it. Malad, we are not getting it. That's ultimately. So, Malad, the recommend, Malad, ultimate authority is the board. Malad, my Malad submission is that it is for the employer prerogative, not for the state. State, Malad, only can consider that there is a need of certain teachers and say these are the vacant posts, teachers are not there. You consider how it is to be filled up, not more than that. But here the statute, Malad, the section gives the power to the state to direct. Do it. Malad, board is a statutory authority. It is an autonomous body. Malad, certainly, that's why, Malad, I drew your lordship's attention to section 27. If there is this, Malad, if it picture comes before the state, that these are the number of vacancies, you just deploy the teachers accordingly. Malad, these suggestion can be given by the state to the board. But the court, Malad, state cannot say you transfer X teacher to Y school. You cannot finger it. This is not the, Malad, power. This is unbridled power state is reserving within itself. It is for the board because the board ultimately, the matter of secondary education has been vested by the act to the board. To the board. State has the power. You immediately pointed out subsection 2. Malad, that's the direction, Malad, in respect of carrying out the provisions of the act. But carrying out the provision of this act does not mean that the state will direct you to transfer X to Y school. By preparing a chart, you do it. This is not this, Malad, within the domain of the state. This is within the domain of the employer. And if the Malad, that's very notification goes, then nothing remains. That's your loss is another aspect. Malad, kindly consider this judgment. Malad, kindly excuse me, one is stitched and another is
exchange.
Malad, if you lost
So it is stapled.
it is stapled, but it losses without stitching.
Change হয়ে গেছে আপনার
Oh, I mean, well, this is reported in 1988, volume 2 SCC, page 351. Well, it's not a very longest judgment, but it's a very important according to my assessment, your losses. Well, kindly take paragraph 2. 1988, volume 2 SCC, page 351, sir. The appeal is directed against the judgment of the Allahabad High Court striking down paragraph 2. What I feel, I have to place the entire
Which one? Which one?
paragraph 2, my lord. The appeal is directed against the judgment of the Allahabad High Court striking down Rule 5C of the Cantonment Fund Servants Rules 1937, hereinafter referred to as the rules as ultra vires of the provisions of the Cantonment Act 1924, and also quashing the impugned order of transfer dated October 27, 1986, passed by the GOC in chief of the Central Command. The respondent, Dr. Subhash Chandra Jadhav, was appointed a sub-charge, Cantonment General Hospital, Lucknow, by the Cantonment Board by appointment later dated April 23, 1969. He was confirmed in that post on December 1st, 1969 by an order issued by the Cantonment Board. The conditions of service of the employees of the Cantonment Board, which is a statutory body, are governed by the provisions of the rules. At the time of appointment of the respondent, his services were not transferable as per the provisions of the rules then prevailing. His appointment letter also did not include any condition for transfer from one board to another. By notification dated December 16, 1972, the rules were amended, and a new rule, being Rule 5C, was added to the rules. Rule 5C reads as follows. 1. The service of a servant shall be transferable from one post in one board to another post in another board, provided that the transferor and the transferee boards are situated within the same state, and the posts in both the boards are similar and carry the same scale of pay. 2. Subject to general conditions as the central government may issue from time to time, the officer commanding in chief, the command, or such other authority as may be authorized by the central government in these behalf shall be the competent authority to transfer a servant under this rule. 3. A servant on transfer under sub-rule 1 from one board to another may, for the purpose of determination of seniority and eligibility for promotion, opt 1. To be governed by the conditions applicable in this behalf to the servants of the board from which he has been transferred, hereinafter referred to as the transferor board, or 2. To be governed by the conditions applicable in this behalf to the servants of the board to which he has been transferred, transferee board. Provided that where a servant does not opt under this rule within 30 days from the date of assumption of charge in the transferee board, he shall, for purposes of promotion and seniority, be governed by the conditions applicable in this behalf to the servants of the transferor board. 4. Save as provided in the sub-rule 3, the terms and conditions of service of a servant transferred under this rule shall be deemed to be those applicable to the servants of the transferee board. Where the servant opts under clause 3 of sub-rule 3, the service put in by him on the transferor board before his transfer shall be doomed to be in service on the transferee board. For the first time, Rule 5C provided for the transfer of the service of the employees of the Cantonment Board for one post to another post in another board within the same state. The GOC in Chief Central Command, by his order dated October 27, 1986, transferred the respondent from the Cantonment General Hospital, Lucknow, to the Cantonment General Hospital, Varanasi, in place of one Dr. Bansal, who was also transferred by the same order to the Cantonment General Hospital, Bareilly. Being agreed by the said order of transfer, passed under Rule 5C of the rules, the respondent filed a writ petition in the Allahabad High Court challenging the validity of the order of the transfer on the ground that the 5C was ultra vires the provisions of the Cantonment Boards and as such void. As has been stated already, the High Court has struck down the Rule 5C holding inter alia. The services of the employees of the Cantonment Board are neither centralized nor is there a common state level service. But I told you last week yesterday, cadre and state level service doesn't exist in our case. And the impugned Rule 5C having provided for the transfer of the employees of one board to another board by the GOC in Chief Central Command is beyond the rule-making power of the central government as contained in clause C of subsection 2 of section 280 of the Cantonments Act as it stood before it was amended. Hence this appeal. Then Malak section 280 of the Cantonments Act. Power to make rules. Central government may, after previous publication, make rules to carry out the purposes of the objects of this act. in particular without prejudice to the generality for the foregoing power. Such rules may provide for all or any of the following matters, namely, the tenure of service, office, salary, all that, and other conditions of servants of the boards. Matlab, the earlier provision was that only for appointment, control, supervision, suspension, removal, dismissal, punishment of service of boards. Matlab, so for the other conditions of service of servants of board, there was no provision earlier. It is apparent that before the amendment, clause C did not confer on the central government power to frame rules regarding conditions of service, which necessarily include transfer of the employees of the boards. Rule 5C, which was inserted in the rules by notification dated November 23, 1972, providing for the transfer of the employees to the cantonment board, is on the face of it contrary to the rule-making power of the central government as it stood before the amendment of the Act in 1983. It is, however, contended by Dr. Rajaram Agarwal, learned counsel appearing on behalf of the appellants, that after the amendment of clause C of subsection 2 of section 20 to 80 of the Cantonments Act, conferring on the central government the power to lay down the conditions of service of the employees of the board, which include the power to make rule for transfer, Rule 5C is valid, being quite in conformity with the provisions of the rule-making power under section 282C of the Cantonments Act. We are unable to accept the contention. When Rule 5C was inserted into the rules, it was void as being contrary to and in excess of the rule-making power of the central government as contained in the unamended clause C of subsection 2 of section 280 of the Cantonments Act. It doesn't become valid merely because of the amendment of clause C inter alia, conferring the power on the central government to frame rules relating to conditions of service. Our attention has been drawn to the provision of subsection 2 of section 281 of the Cantonments Act, which provides that all rules made under the Act shall be published in the official gazette and in such other manner, if any, as the central government may direct, and on such publication shall have effect as if enacted in the Act. It is urged on behalf of the appellants that in view of subsection 2 of section 281, Rule 5C becomes part of the statute, and accordingly the question of being contrary to the provisions of the cantonment doesn't arise at all. This contention is unsound. It is well settled. The rules framed under the provisions of a statute form part of the statute. In other words, rules have statutory force. But before a rule can have the effect of a statutory provision, two conditions must be fulfilled. Namely, one, it must conform to the provisions of the statute under which it is framed. Two, it must also within the scope and purview of the rule-making power of the authority framing the rule. If either of these two conditions is not fulfilled, the rule so framed would be void. The position remains the same even though subsection 2 of section 281 of the Act has specifically provided that after the rules are framed and published, they shall have effect as if enacted in the Act. In other words, in spite of the provision of subsection 2 of section 281, any rule framed under the Cantonment Act has to fulfill the two conditions mentioned above for their validity. The observation of this court in Justami Gulabari Dhalokia, relied upon by Mr. Agarwal, a contract of service may be transferred by statutory provision, does not at all help the appellants. There can be no doubt that a contract of service may be transferred by statutory provisions, but before a rule framed under a statute is regarded as statutory provision or a part of the statute, it must fulfill the above two conditions. Rule 5C was framed by the central government in excess of its rule-making power, therefore void. It is not disputed that the cantonment boards are statutory and autonomous bodies controlled entirely by the Cantonments Act. Each cantonment board is an independent body functioning within its limited jurisdiction. The board is the appointing authority of its employees. The service of the cantonment board is not a centralized service, nor is it a service at the state level. Well, this is very vital, my lord. Then 16, there is much force in the contention of the respondent that as service under the cantonment board is not a centralized service or a service at the state level, the transfer of an employee from one cantonment board to another would mean the termination of appointment of the employee in the cantonment board from which he is transferred and a fresh appointment in the board where he is so transferred. The GOC in chief central command is not the appointing authority of the respondent or the employees of the cantonment. So transfer of the respondent by the GOC in chief is not permissible. In any event, one autonomous body cannot transfer its employee to another autonomous body, even within the same state, unless the service of the employees of these two bodies are under a centralized or a state level service. Now, Prakash Rana was placed before Malad, and then your losses kindly paragraph 19.
Prakash Rana was in relation to education.
I beg losses.
Om Prakash Rana was in relation to education.
Exactly, Malad. That's in the education. Now here, Malad, this
I have read up to the last paragraph.
Malad, I am this is so fast, your losses, as usual. Malad, I am relying on this judgment for
What proposition?
my proposition, Malad 2. Malad, first your lordships. Here your lordships, your lords fine. State, Malad, the legislature gives the power in a state in an act which is not, Malad, in an act, a provision which doesn't conform to the statute, to the purpose or object of the statute. Malad, that's my submission, your lordship.
This judgment does not.
That doesn't say, Malad, it says the Malad, it's conformed, Malad, rule making power must be conformed to the statute. I am extending it little, Malad, kindly consider it. If it is contrary to the object, legislature, Malad, that's Malad beyond the.
The judgment is something different.
Well, judgment is to an extent different. Only first point. This is my submission, your losses considered. That, Malad,
You are propagating a particular law point, but you are not.
I will, Malad. Now, the second your losses you'll find, as I told your losses, there is no cadre, not this is state level service. Malad, therefore, there cannot be any transfer. State cannot reserve the power of transfer to it and to direct it to the others. So, therefore, Malad, this provision is ultra vires of the object of the statute and Article 14 of the Constitution of India. Then your losses can be considered it. Malad, this is your lordships. Allahabad High Court judgment. Malad, kindly Malad reported in. Eta kothay reported to noy. Eta ki debo. Particulars to Malad. I'm giving your lordships. Malad. Prem Bihari Lal Saxena versus Director of Medical and Health Services, Lucknow. Prem Bihari Lal Saxena. Monupattu. Reported. Monupattu te gasche. Malad, here your lordships would kindly consider this is in respect of post-wise appointment. Post-wise appointment. If this is a post-wise appointment, there cannot be any transfer.
That is a single bench decision.
I beg lordships. Exactly, for the logic. Persuasive force. It's not binding upon your lordships. I'll be just telling that. Kindly see the logic behind it.
What is a persuasive force?
Only the logic?
Because of
Logic, your losses.
because of the surname only. Huh?
Well, that's your loss. See the logic, the reason behind it. I can't say this is binding upon your law at all. Kindly have a look at this. Well, your losses will find. Your losses here will find, my lord, in a monopatri problem. My lord,
I don't believe, because there are a lot of typographical error in one of the judgment. I could find that what has been stated, one or two line was omitted, and the entire consideration or whatever the logic that God's blood, I just perceived just opposite to what has been said, and I was unable to comprehend or make a assimilation of that paragraph with the last paragraph.
But I have read
That
it
is the whole
entirely.
problem. Now
Uh,
you have a,
Read it, Malad. I do not find any inconsistency. Missing of line I can't, but I will give your lordship the reported copy. But your lordship kindly consider this judgment. Malad, page 2. Malad, I'll just tell your lordships. Here it may be mentioned that the advertisement issued by the Public Service Commission was for 2 posts of anesthetist, 1 each for Allahabad and Kanpur. The petitioner was ultimately selected by the Public Service Commission for the post at Kanpur and recommended accordingly to the state government. Subsequent to his recommendation of the government made the appointment of the petitioner. There are 2 such orders, one issued in 1950, in which there are certain terms which it seems were not acceptable to the petitioner. The latter thereafter represented against them to the state government, which modified the earlier terms, issued a fresh appointment on 1951. It appears some further difficulty about the terms, which were ultimately modified and communicated to the petitioner. As far as the appointment of the petitioner went, it took place under the order of the governor. The relevant portion of this order, in supersession of this office order of 1950, the governor has, subject to the approval of the Public Service Commission, Allahabad, UP Allahabad has been pleased to appoint to the post of anesthetist, Medical College Associated Hospital. The order describes certain conditions, including he shall be on probation for a period of 1 year. What is significant, however, is that no mention was made in this order about his liability for transfer from the post to which he has been appointed, The petitioner continued to serve on this post thereafter and was ultimately confirmed. Then your lordships will find in the next but the paragraph, the reply he got, however, that it was an ex-cadre post, meaning thereby he could not be placed on the cadre of one of the other services. In October 1957, he was served with an order annexing 9, transferring him from one of his posts, then the post at Kanpur at Varanasi. On receipt of the order presented by the director that such, inasmuch as his appointment was to a specified post, namely anesthetist, he was not liable to be transferred. But while maintaining this position, he also offered in the case that he was placed on the cadre of one of the other services, he had no objection to moving to Varanasi. The grounds, the next page you'll also, after the 2 paragraphs, the grounds asked are that he was appointed to the particular post at Kanpur, and as such, he was not under the terms of his employment liable to transfer. The alleged charge of the disobedience is also disputed. It may be stated at the outset that the Standing Council has considered that the petitioner appointment was made by the governor and not by the Director of Medical Health Services. It also has not been challenged that the suspension order was made by the Director aforesaid. As regards the other facts, also does not appear any dispute, inasmuch as the Standing Council has not pointed out any material on record to support that the petitioner's appointment was subject to liability. The term of appointment do not state any such liability, nor has any other document been produced to show that it was thereby incorporated in them or that existed by virtue of that. Now, reliance was played on Rule 15 of the fundamental rules. Then your losses will find the facts which may therefore be taken not disputed, that the petitioner was appointed by the governor and his appointment was to the post of anesthesia attached to the State Hospital Kanpur, and he was confirmed to that post ultimately, and the appointment order imposed no express obligation for transfer from that post. Then your losses, paragraph 5. So far, therefore, as the terms of employment, they fail to attach any condition in favor of transfer. The question which will still have to be seen is whether Rule 15 of the fundamental rules, which gives the power to the state government to transfer government servant from one post to another, conferred by necessary authority on the director to order petitioner's transfer from his post at Kanpur. This rule undoubtedly gives power to the state government to transfer a government servants from one post to another. The transfer contemplated by this rule is, as its language clearly indicates, from one post to another post. Before, therefore, this rule can be availed of, the government servants must belonging to a category of servants which can in accordance with the terms of employment be sent to another post. Where a government servant has been appointed to a specific post, and that post is in its very nature such that it cannot be performed at a particular place only, he cannot under this rule be transferred to another post. In such a case, transferor will in fact run inconsistent with the appointment itself, which is not generally to a class of post, but to a specified post only. This ultimately boils down to the issue. If it is a specific appointment to a post and there is no cadre or category, therefore one cannot be made liable to be transferred. For this proposition, I am playing, this is for the logic behind it. Then your lordships, 2013, volume 3 SCC, page 5 to 6. Now, I'll be placing here, lordships, the paragraph 24. Paragraph 24. Paragraph 24. Now, before concluding, it is essential to deal with certain inferences drawn by the learned single judge of the High Court. According to the learned single judge, prior consent of an employee is imperative, binding, peremptory, or mandatory before he is posted on deputation outside his parent department. No statutory rule has been brought to our notice requiring prior consent of an employee before his deployment against a post beyond his parent cadre. The mere fact that the applicant's consent was not sought for before their posting at Government Medical College, Jammu, would not, in our view, have any determinative effect on the present controversy. Broadly, an employee can only be posted or transferred to a post against which he is selected. This would ensure his stationing within the cadre of post under his principal employer. His posting may, however, be regulated differently by statutory rules governing his conditions of service. In the absence of any such rules, an employee cannot be posted or transferred beyond the cadre to which he is selected, and without his willingness and readiness. Therefore, an employee's posting to a department other than the one to which he is appointed against his will would be impermissible. Not all that I'm trying to say, your losses, by this judgment, that I have been appointed against a post of a specific school. Against my will, my lord, I cannot be transferred. Mutual transfer is according to my wish, subject to the approval of the government. It's not mandatory. But
and the general transfer is also at your wish, subject to an application taken out by you.
general transfer also. If I made an application at all, if
That
I
is
do
what
not
say,
make,
subject to an application.
so your lordships, these
So your wish is paramount.
my lord, in a nature of the present nature of service, in the present nature of service.
And the governance and administration of the system is all together secondary.
My lord, if the nature of service and the rules do not permit that, subsequently this cannot be done for the teachers, by the persons who are holding the post.
Yes.
My lord, this is AIR 1953 Supreme Court, page 375. What am I doing? My lord, I will be only, my lord, paragraph 9. This is on the proposition, your lordships, that a statute, my lord, when can be said to be invalid or colorable class of legislation, when it, my lord, goes against the limitation of the legislative authority in the shape of fundamental rights when it becomes arbitrary. Paragraph 9, your lordships kindly consider. I think, my lord, paragraph 9, the second paragraph I am relying upon mostly. না না আমার গুলো না ঘাটিস না, আমার ঘাটলে মুশকিল হয়ে যাবে। এটা তোর আছে? হ্যাঁ আচ্ছা, বার করে যা। না, এখনো হয়নি। Judgment করতে গেছে কিন্তু জজের
Yes.
Now I kindly consider this from the, well, each judgment cannot be applied vacuum with certain facts. Well, I am not an employee of the state. I am an employee at best now, if you losses take the latest amendment of the board. The power given to the state to direct commission to recommend, commission will recommend to the board, board will transfer. Well, this is something your losses arbitrary and against the constitutional matter. Just why, my lord, I'm just, my lord, for your, with the lordship's leave, I'm just, my lord, reading out this. If the constitution of a state distributes the legislative powers amongst different bodies which have to act within their respective spheres marked out by specific legislative entries, or if there are limitations on the legislative authority in the shape of fundamental rights, question do arise as to whether the legislature in a particular case has or has not, in respect to that subject matter of the statute or in the method of enacting it, transgress the limits of his constitutional powers. My lord, here your lordships, I'm not an employee of the state, I'm an employee of the board. Had it been a provision, your lordships, that service conditions will include a transfer and gives the board to power to transfer a teacher, probably I could not have, in respect of at least prospective in nature, I could not have.
Mr. Sanyal, there are one thing. What is the birth of the board?
Part of the board by the legislature.
Who procreate the board?
My lord, legislature.
State.
My lord,
Having a legislative powers under the constitution to make a law. Unless the West Bengal Board of Higher Secondary Education Act comes, board would not have seen the birth. It sees the birth from that act enacted by the state, I think the assembly, within the powers conferred under the constitution. That is a list, I think the schedule 9, state list, state concerned list.
admittedly state list.
If that being the position, the state has a power to amend that act. A state has a power to repeal the act. A state has a power to legislate new act after repealing the old. Is it?
Yes, your lordship.
If the state has amended the parent provisions and have taken away certain powers from the board and reserved upon itself, will you still say that this power exercised by the state within the contour of the constitutional provision,
My lord, I tell you, lordship,
the
in the
colorable legislation? Only 3 grounds. Because is a lifting of veil is what is very important in paragraph 9 says. It says that the particular act may be ultra virus if it is patent, manifest, or apparently apparent from the face of it. It may sometimes in disguise, covert or indirect, they want to do it. This is what the Supreme Court has said that comes within the peripheral of colorable legislation. First one does not, which is apparent, patent, it has to go. But then the Supreme Court has said, please lift the veil. You have to. Only thing is, who is doing it? If the board is doing something beyond the powers which is conferred in the act, certainly you are correct. Certainly you are correct. All these judgments you have cited is that even that particular case of the Supreme Court, there was a different cantonment boards in different, the places within the state. Every cantonment board has the power over all these command hospitals or the hospitals within that. By this legislation, they say that one cantonment board can transfer one person from one hospital to another hospital of another cantonment board, but within the same state. The Supreme Court said, how can you do it? You are an employer. You have employed in an hospital within your command, and you can transfer a person beyond your command. That cantonment board is an independent autonomous body. You can't transfer it. Then in that perspective says it is not a central service or a state-based service where the one agency is controlling the entire thing of the state. And if you have not, then one board cannot. Suppose a school situated in Purulia and a school situated in Birbhum. The managing committee of the Purulia, he says, I hereby transfer you to Birbhum. Can it be done? It's a different one. It's a different. You don't have the domain. You are the employer of this school, of this in this school. How can you transfer? That is what the principle that comes. There are 2 exceptions that has been done. We are, again, I am repeating, we are concerned with, so far as the virus of 10C is concerned, whether the state was competent to incorporate section 10C. if this state was absolutely incompetent, then certainly you can say that it is ultra vires. Secondly, if it really disturbs the very fabric of the act itself, it's so alarming, then I can understand. One can say it totally disturbs the very fabric of this act itself.
Now, that's the second point that I'm trying to ask.
I'm saying that
Well,
I can understand that, but all these judgments which are
Well,
which you
all
have
that I'm
cited
trying
is-
to say by this, your lordship.
yes, you saw that. What is that?
Well, kindly
Colorable legislation in that.
colorable, why I'm saying, trying to say, your lordships. My lord, normally power of transfer lies with the employer.
Who disputes?
That's your lordship.
Nobody
Now, the
disputes.
employer is the board. Now, if your lordship at best, or else managing committee. Can there be a legislation or provision, new provision introduced in the act of the School Service Commission, which has the power only to select and recommend for appointment?
No, I'm again I'm saying power to legislate is one thing. How they will legislate is another. And how they can intrude is the third concept.
Well, that's I'm trying to say, your losses. This is colorable. Because what the Malad could have been done, they have not done. They have done in a different way the reserving power.
Because all these judgments are where the rule-making power was being misused and abused by the particular authority.
No,
Suppose a board who has been given a power to make a rules in relation to a particular subjects, and the board makes a rules which is absolutely divorce. You can definitely say you can't, because, and if you have done it, it is a colorable legislation. You can't do it.
That's an ideal case, your lawsuit saying that.
But
Always
sometimes-
we can't get the ideal case, but
No,
your
the
lawsuit has
ideal
to.
case is this.
Well, that's I have to show you that I'm trying my best, your lawsuit, to show that kindly see initially all were different managing committees. Our appointment was that. By each managing committee was my appointing authority.
But now that has been
That has been changed by legislation after
Okay.
20 or
Now-
25
now
was my
question is-
service.
No, the first intrusion in your domain can be visualized when 1997 Act was introduced. I think prior to 1997 Act, there was a school education, I think West Bengal School Education, Secondary Education Act was there.
That's 1963 Act. That's the
This
thing.
was there. First intrusion came in when this Service Commission Act came, where appointment, the selection, everything has been taken away from you. Now it is the School Service Commission who started selecting the candidates, the teachers. First taken up. Now, the moment this comes, and then the appointments recommendation was made to the managing committee, who had no other choice
No other choice.
but to put a rubber seal in a mechanical manner, issue a letter of appointment. That's all. Can the managing committee deny that I will not issue a letter of appointment?
No,
Ah,
no.
bound. So you have accepted that position. Now, secondly, by virtue of an amendment, they took away the power
No,
of the
Malad,
managing
kindly add here with little, your lawsuit. Kindly
Now,
permit
question
me.
is whether notified
No,
or
no,
not
your lawsuit,
notified.
no. When the
That's a-
commission comes, even then my service conditions are not changed.
Oh,
Service conditions remains the same.
that-
Only the appointing authority,
Sir.
recommending authority comes in.
yes, that's why I'm saying. Now the question would be that what would be the service conditions? Can it be altered? Cannot be altered? How? To what extent? Whether the provision relating to transfer alters the service conditions is one of the very important factor.
Yes.
One of the, because these are all the incidents of the service. Some services may not be transferable, some services are transferable. It all depends. And how the system has to work, a larger perspective. Let us see offending a particular provision of the act of an individual vis-a-vis the larger society. if we protect the right of an individual, but it takes away the right of a larger section of the society,
मतलब larger section
what will prevail?
मतलब larger section means मतलब the vacancy to be filled up.
Or what will prevail?
Larger.
I think the latter. Yes, come tomorrow and finish it.
Certainly.
Sorry, today was absolutely beyond my court management power.
My lord, I did walk in twice, my lord, and realized, my lord, that. My lord, I walked in twice, and my lord, I realized, my lord, that we've all, my lord, my lord, match, my lord.
ঠিক আছে,
My lord, only one thing, my lord, I told your lordships, my lord, before. My lord, tomorrow and day after, my lord, will be, my lord, for the better part of the day, my lord, in court 1. I'll be here, my lord, in the morning. My lord, moment I'm called on there, my lord, I might have to go. My lord, I'm told, my lord, they will take, my lord, some time, my lord.
Let them start and
Yes.
continue, because
Yes.
once we started, we must come.
Yes, yes,
finish.
my lord, I'm grateful.
10:30? Continue. Sorry, today it was also 10:30. We just thought that one or two release matter, where I will release the matter will come, and then thereafter I will do it. But yes, no extension of interim order. No.
No small matter.
No matter.
কি বুঝবেন না আমাদের করে আবার কোন একটা urgency আছে
Thank you.